Okay, can you wait a moment?
Should be on. All right, let's start with Shorna Wright.
Good morning, Judge.
Good
Ms.
mor-
Shona Wright is here, present at Maine.
Okay, and we have an attorney, Mr.
There's your title.
David McGilligan.
McGilligan. I wanted to pronounce that correctly. How are you today, sir? All right. Good morning, Miss Wright. How are you?
Good morning, I'm fine, thank you.
Good. All right. You're charged with one count of domestic violence battery. Mr. McGilligan, I've had an opportunity to review the probable cause affidavit. Do you wish to be heard?
No, there's no issue about the probable cause, Your Honor.
Okay. All right. We just discussing bond then?
Yes, Your Honor.
Okay. Mr. Linder?
Thank you, Your Honor. Eric Linder on behalf of the state. Your Honor, even though I do know that Ms. Wright was charged with misdemeanor battery, but I would note the allegations are that the victim was struck with a clothes iron and suffered a fractured left orbital bone. It would appear that this actually could support a felony charge. I'd be requesting a $7,500 bond and no victim contact.
Mr. McGilligan?
Well, Judge, I spoke with the detective yesterday about the charges, and he told me that the injuries weren't that severe, that he had met the victim, alleged victim, after the incident. He said the swelling was already going down. He said, and he was the one who made the charging decision, who had two opportunities to meet with the victim. I would just say ask for a standard bond or pretrial release, Your Honor, if that was available.
Okay. What are you looking for in the standard bond area?
Judge, $2,000 bond?
All right. We'll do $2,000 bond, no victim contact. Ms. Wright, listen carefully, okay? Do not make contact with the victim of any kind. Do not call, do not text, do not use any form of social media. It doesn't matter if it hasn't been invented yet, okay? If they invent a new form of social media tomorrow, don't use it. Fair enough? I'm sorry?
It's already been dealt.
Yes, sir.
All right, perfect, thank you. All right, and anything else? All right, that'll be that. So $2,000 and no victim contact.
Thank you, Your Honor. Have a nice day.
Your Honor, the jail is called requesting two cases to be called out of turn.
All right, which ones?
On page 15, Mr.
Lenny Dussault.
DeSalt, and on
Mr.
page,
Dussault, come on
on
up,
page
please.
16, Mr. Brown.
And Mr. Dussault is approaching Judge here at the podium, and this is a minute ordinance.
All right.
Morning.
Good morning, sir. How are you?
Good, thank you.
All right, and that's, what did we say, what page it was?
Page 15.
I don't know what copy it would be. Is there a copy of the docket up here?
Stephen Shade on behalf of Mr. Dussault.
All right, Mr. Shade.
Miller.
Let's take a look here. Thank you.
You're welcome.
All right, Mr. Dussault, we have you're charged with one count of municipal ordinance trespass. Thank you.
You're welcome.
Mr. Shade?
I couldn't hear you, sir. I'm hard of hearing.
Okay, you're charged with one count of trespassing under a municipal ordinance, okay?
Judge, the city of
Yes,
Fort
sir.
Lauderdale would offer Mr. Dussault a time served plea.
Okay. Do you want to accept that?
Yes, sir.
All right, you
I want to
understand?
resolve my case today.
You want to resolve your case today?
Yes, sir.
Okay, you understand that you're pleading to a trespass?
Yes, sir.
Okay, and you want to do that today? You want to enter a no contest plea?
Yes, sir.
All right, we'll go ahead and accept Mr. Dussault's no contest plea to trespass. Credit time served.
Thank you, Judge.
Thank you, sir.
Thank you very much.
You're welcome. And that's the name you gotta-
Got it, thank you. And then we have Mr. Brown.
He's approaching Judge here at Maine.
Good morning, Mr. Brown, how are you today?
I'm all right.
All right, you were picked up on a capias for what looks like driving while license suspended. There's currently a $500 bond. Do you wish to be heard as to Mr. Brown?
Yes, Judge, and speaking to Mr. Brown earlier today, He wishes to ask the court if the court would consider resolving the case, so we wanted to see if the state had a plea offer for him.
Mr. Linder?
Documented offer from the state would be an adjudication, court cost, Your Honor. Time served.
Adjudication, court costs, credit time served.
Judge, after discussing Mr. Brown's options, he wishes to accept the state's offer.
All right. Mr. Brown, you understand you're pleading to the charge of driving while license suspended?
Yes, sir.
All right, and you're entering a no contest plea?
Sir.
All right, have you had enough time to speak with your attorney?
Yes, sir.
All right, and you understand you're not taking this to trial, right? You're going to resolve this today, and you're waiving a whole bunch of rights by doing that. You understand that?
Yes, sir.
You're waiving your right to call witnesses, you're waiving your right to cross-examine witnesses, you're waiving your right to appeal this to a higher court. Do you understand all of that?
Yes, sir.
Okay, and are you under the influence of any alcohol, drugs, prescription medication right now?
Sir.
Do you feel, you understand what's going on here today?
Yes, sir.
Okay, we'll go ahead and accept your plea of no contest, adjudicate court costs, credit time served. We also have Kendrick Ashley. Someone's here for, come on up, ma'am.
She's
I have
here
page
present,
4.
Judge, May approaching.
Okay, thank you. Here we go. All right, Miss Ashley, how are you today? I'm sorry, Miss Kendrick, how are you? All right, you're charged with 1 count of aggravated assault with a deadly weapon without intent to kill. And ma'am, you are? All right. And did you wish to be heard today?
Yes.
What would you like to tell me?
I still feel like I'm in fear and I don't feel comfortable with her being out, but if she do, I'm asking for a higher bond and maybe house arrest or something.
Okay.
Because the simple fact that she aimed a gun towards my head and kept coming to my residence in my mother's house.
Okay.
Could I have 1 moment, please?
Sure.
Thank you.
I had a chance to review the probable cause affidavit. Do you wish to be heard as to PC defense?
My
No,
colleague
Judge.
does.
Okay. We'll find probable cause, we'll find, and then let's see as to the bond.
Your Honor, if I could just briefly just ask the alleged victim a couple questions.
Sure.
Ms. Dinkins, I see that you also have obtained a permanent injunction against Ms. Kendrick. Is that correct? If you speak into the microphone, please, and I need you to give yes or no answers.
Yes.
Okay. And in your petition for seeking the injunction, you advised the court that there's been more than just this one occurrence, this incident that is
Yes.
before the court today, correct?
Correct.
So could you please tell the court if there's been a pattern of any violence or threats of violence against you by Ms. Kendrick?
Yes.
Could you please advise the court what those consisted of?
Like, you mean like what happened?
What has she done, what threats, if any, has she made in the past against you, Ms. Dinkins?
Basically like threats telling me what she was gonna do to me. He's showing up to my house, even to my mother's house. She even came to my mom with the same firearm, telling my mom she was looking for me to shoot me. My mama had to talk to her and stuff, but she still ended up coming way to Pompano Beach where I live at numerous of times. The threat to hurt me and stuff, and it was times that I was outside already. She'll pull up and be sitting there, close by my apartments watching me and stuff like that. Yeah, I just don't trust her. I really don't, because she could have killed me. She could have killed my roommate and my niece.
Thank you, Ms. Dinkins. Your Honor, as far as criminal history, I would note Ms. Kendrick, she only has a prior petty theft. That being said, I do have a concern about the alleged use of a firearm, included alleged threat to kill in the probable cause affidavit. I would be requesting a $15,000 bond, no victim contact, should she post her bond, pretrial release with a GPS monitor, and no firearms or weapons until further order of the court.
All right. Defense wish to be heard?
Yes, Judge, I wish to be heard.
Okay.
I did advise Mr. Kendrick. She had a lot to say regarding this incident. First off, I believe the date of this incident was earlier this year. I did advise her that this is a non-adversarial hearing, and unfortunately at this time, we don't have a chance to cross-examine the alleged victim. But my understanding is that also Ms. Kendrick sought a restraining order on the alleged victim herself. She is disputing all of these allegations. She is looking forward to her day in court. Now, I know the alleged victim mentions as far as Ms. Kendrick coming up to her residence, but also Ms. Kendrick has proof that the alleged victim sent her numerous text messages also threatening her and advising that she would be coming over her house. So, Judge, this is basically a he said, she said type of situation. Now, my understanding is Ms. Kendrick does have independent witnesses that were there on the day of incident, but I did advise her that's going to be determined at a later date. And all those facts are in dispute right now. What we cannot argue is the following, Judge. Basically, she has no prior violent felony offense. She has very strong ties to the community. She's been residing in our community her whole entire life. She graduated from high school. She is a single mother supporting her 2 children, Judge. She lives in Fort Lauderdale, and right now her 2 kids are with her grandmother. My understanding, Judge, where she's been living at, she's renting. She does not own, and she's been living there for the past 6 years. She is employed. She works at Costco. She's been there for 1 year, making about $13 an hour, trying to raise her 2 children, Judge. I'm asking this court, considering basically Ms. Kendrick's lack of financial resources, her very strong ties to community, the credibility of the victim at this time, Judge, it is shaky at best from the defense's point of view. I'm asking, Judge, for the court to consider setting a $1,000 bond. We'd have no objection with pretrial at this point. The only person that's going to help post her monetary bond is her grandmother. Her grandmother's on a disability. So there is no more financial money that she can come up with, Judge, to post a bond. That is what we are asking for at this time, Judge.
Okay. I understand the arguments by the defense are well taken. However, at this point in time, I am going to make it a $15,000 bond, pretrial release with GPS monitor, no contact. I lost the screen there. There we go. No contact with the victim. All right, Ms. Kendrick, you'll have your day in court. You'll have your opportunity to call your witnesses and do everything you need to do. But for right now, as we indicated earlier, this is not non-adversarial hearing. And based on the 4 corners of the probable cause affidavit, I feel that the bond is appropriate at this point in time. And we'll go ahead and do that. You are not to have any contact with the victim, okay? Don't call, don't text, no third-person contact. Don't have anybody call or text the victim, okay? You understand?
Yes, sir.
Okay. All right, anything else at this time, folks? All right, thank you very much, ma'am. All right, and we have Jonathan Gray. I have page 25. I got it. Yep, thank you.
Judge, our cutoff, I believe, is page 21. So everyone after 21 is not here yet. They're
Got it.
going to get Mr. Gray.
Okay.
So I will let the court know when he arrives.
Perfect, thank you very much. All right, so we'll set that aside, just sit tight for a second, ma'am, okay? And then we'll have an opportunity to talk to you. Got it. Yep. All right, what about Tuesday Davidson,
She's in North Broward, Judge.
North Broward, Your Honor.
North Broward?
She might be interested in resolving the case today.
Okay. Ms. Davidson, good morning, how are you today?
I'm alright. I'm alright.
All right, you are charged with 1 count of trespassing, occupied structure of conveyance. Did you want to resolve this today?
Yes, sir.
All right, state?
Yeah.
State?
Your Honor, I'm sorry. State's offer, if she wishes to resolve the matter, the state's offer would be an adjudication, time served, no return.
All right. Ms. Davidson, did you hear that? The offer is adjudication, credit time served. Do you want to resolve it for that?
Yes, sir.
Okay, you want to enter a no contest plea?
Yes.
All right, you understand you can't take this to trial? You're going to go ahead and waive
Right.
all those rights to resolve this today?
Yes, sir.
All right, you okay with that?
Yes, sir.
All right, we'll go ahead and adjudicate credit time served. All right. Good luck to you, ma'am. Thank you.
Thank you.
What about Kaylin Berghart?
She's approaching approaching, Judge. She's here at Maine.
I got it.
All right.
Yes.
Good morning, ma'am. How are you today?
I'm good, how are you?
All right, can you pronounce your last name for me?
Burkhart.
Burghardt. Okay, I just didn't know if I got it right. Okay. And ma'am, you were picked up on a misdemeanor capias, case number 1788MM40. I can't see if that's right or not, but and it looks like it was a delivery charge, 20 grams of cannabis, less than 20 grams. There's currently a bond of $5,000 on it. Do you wish to-
Correct, Judge. My understanding is, Ms. Burkhart advised me that she's on probation in Dade County. I don't know the specifics. So at this time, I see she has court tomorrow at 8:30, so I'm gonna ask the court not to take any action on this. She has court tomorrow.
Okay, perfect. All right, good luck to you, ma'am. All right, found probable cause. All right. What about, Mr. Shade, are you ready? Where'd he go? All right, let's see here. Page 14, Ballinger.
She's got 2 city cases.
He's approaching, Judge.
All right. There you go.
Judge, the city of Fort Lauderdale would offer my time served offer on both matters, the panhandle as well as the alcohol violation.
Okay. Mr. Ballinger, would you like to resolve your case today? You're charged with a municipal ordinance violation, and that is for panhandling, and then you have a capias for alcoholic beverage violation. And I'm sorry, what was the offer again?
Time served, Judge.
Time served. Would you like to resolve this for time served?
No, I'm not guilty, I didn't do nothing.
Okay. Want to enter a not guilty plea at this point in time, and there is a bond for $25 on each count. Will find probable cause, and it looks like you're set for court on the 11th of July, okay?
Which is tomorrow, Earl, so I'll see you tomorrow morning, okay?
Okay.
All right. Good luck to you, Mr. Ballinger. All right. And what about,
You can have a seat, Earl.
think you're all set, Mr. Ballinger. You'll have court tomorrow. All right. What about Edward Thompson?
He's approaching, Judge.
Okay.
Come on up, sir. Judge is calling you, sir.
Good morning, Mr. Thompson. How are you today?
Morning.
All right. Mr. Thompson, you have a capias for an open container of alcohol. Mr. Shea?
Judge, it's gonna be a time served offer from the city of Deerfield.
All right. Mr. Thompson, would you like to resolve this case for credit time served?
Yes, sir.
Okay. So you understand that you're entering a no contest plea at this time? You're not gonna have you're not gonna have the ability to take this case to trial or, call any witnesses on your behalf or cross-examine any witnesses? You okay with that?
I understand.
Okay.
Yes, I agree with that.
All right, we'll go ahead and accept your plea of no contest. It'll be credit time served, adjudicate credit time served, and you're all set, okay?
Thank you, sir.
Good luck to you.
Thank you.
And, let's see here.
Alright, no, you're brother. No, I'm just helping you out.
What about Merriman?
Harryman, Judge. My H's look like.
Harriman, I'm sorry, I didn't see it. John Harriman?
Harriman?
Judge, again, this is out of Deerfield Beach. The city of Deerfield offers him time served.
Okay. Good morning, Mr. Harriman. How are you today?
Fine, thank you.
All right, you're charged with one count of unlawful assembly. It looks like it was a warrant, and the city is offering credit time served, adjudicate credit time served to resolve your case today. Do you wish to resolve it today?
Yes, sir.
Okay, you understand you're not gonna have a trial, none of that stuff, none of those rights you get by going to court and being able to fight the charge, you understand you're waiving all those to resolve your case today?
Yes, sir.
You comfortable with that?
Yes, sir.
All right, we'll go ahead and accept your plea of no contest, credit time served, and you're all set. Good luck to you, sir.
Thank you.
All right. And let's see, Sanders, Michael Sanders.
Judge, the city of Hollywood is not offering him a time served plea due to the number of charges he has. They'd rather send this to the division.
Okay. Mr. Sanders, good morning. How are you today?
All right, how you doing now?
I'm doing good, thank you very much. Mr. Sanders, you've got looks like seven open cases or warrants that you were picked up on, and they are, it looks like they are all carrying open container. You've got a panhandling, carrying open container, and no lodging on city property. At this point in time, they're not looking to resolve this, they're looking to send this to division, but you do have a bond on each and every single one of these for $50. All right?
All right.
All right, we're going to go ahead and find probable cause. Good luck to you, sir, okay?
Yeah.
All right, and you have one more, and that is Rear.
Judge, Mr. Cedric Greer, he's been in medical reset about 3.5, 4 weeks now almost. I
Is that-
just reached out to the city of Hollywood. No, this is not Cedric Greer.
No. Is he still on medical reset?
I believe so, Judge. Cedric Greer, he's in, I think it was North Broward at one point, but I'm not sure what.
Your Honor, I looked him up this morning. He's still showing on loan. He's not in custody. He's out on loan.
Okay.
Judge, 620? Okay, Judge, I reached out to the city of Hollywood about possibly null processing this just because it's costing the city, the county, and also he's been medical reset. I guess it'll be reset again tomorrow. Hopefully, I'll have a null process by then.
Okay, great.
Thank you very much.
All right, so y'all don't need anything on this, right? Okay, thank you. All right, and now we have, it's nice to see you, Mr. Shane. And now we have Stacy Wachowski,
That's North Broward, Your Honor.
okay? Good morning, Ms. Wachowski, did I pronounce that correctly?
Yes, you did, sir.
All right, you are charged with one count of trespass, occupied structure. Having reviewed the probable cause affidavit, I find that there's probable cause, you have a $100 bond, okay?
Do we have an offer on this case, Judge?
The offer be adjudication, time served, no return, Your Honor.
Would you like to accept that offer, Ms. Krakowski?
Yes, I do.
All right, Ms. Kachowski, you understand that by accepting this offer, you don't have an opportunity to go to trial or anything like that? If you have any
Yes, I do.
defenses to the case? All right, you wish to waive those rights and enter a plea at this point in time?
Yes, I do.
All right, and the plea is no contest. We'll go ahead and accept that no contest plea. Adjudication, credit time served. Good luck to you, okay, ma'am?
Okay. I thank you.
You're welcome.
Good luck.
All right, Jennifer Harrison,
North Broward?
Your Honor, she's North Broward. She refused.
refused.
Your
Okay.
Honor, I would ask that the court can make a probable cause determination. She's been before the court the past couple days and also had a second look hearing on the top two counts, which are a grand theft on count one, a felony theft on count two. She already had $1,750 worth of
yeah.
bond, and she's got a pending felony theft as well.
Okay.
Yeah, that's fine, Judge.
All right, we'll go ahead and I read the probable cause affidavit. Find PC, there is a bond for $750 and $100. All right. Now, Carla Martinez.
Paul Ryan?
She's in court, Your Honor.
Okay. She's in court, you said?
Yes, Your Honor. Yes, sir.
Okay. Shanika Wittent.
That's North Broward, Your Honor. Come on in this way.
Hi.
Hi, Miss Wynn, how are you today?
I'm good.
Good, okay. You are charged with robbery with a weapon and disorderly conduct, brawl, fight, public place. Having reviewed the probable cause affidavit, I find there's PC.
Your Honor, for record purposes, I would note, it would appear this would be an attempt.
Yes,
I saw
I
that,
do
because it was like
believe that's
a reach
correct.
for the,
Exactly.
yeah.
Your Honor, I would just ask if the court would be inclined to just write
attempt.
in the findings, just so if there is a change of charge, whoever's covering that
Can I
day.
get, Your Honor?
I'm sorry?
Can I get a plea, Your Honor? I would like to return home with my 4 kids.
I understand, I don't think there's a plea offer available at this point in time.
Well,
Not
we
a
couldn't
felony.
resolve it anyway, Judge,
There you
because
go.
it is a felony.
Yeah.
But I would ask the court to consider, in light of the fact that Ms. Wint does have 4 children, and I've read the probable cause affidavit, I'm not exactly sure what happened here,
My mom
but
and my mom is.
I'd ask the court to, hold on, Ms.
Hang on.
Wint, hold on, Ms. Wint.
Ma'am,
I'd
hang
ask the
tight for a
court,
second.
I'd ask the court to consider pretrial release for Ms. Wint.
Okay.
Your Honor, the state would object. As far as what happened, the officer has a sworn report as to what happened for the court's consideration today. And the allegations are that she went up to a police officer, reached for and grabbed his firearm in his holster and attempted to remove the firearm. This was also done at a church where law enforcement was providing assistance to the task force for ending homelessness. I am concerned and would be requesting a $15,000 bond, no return.
I don't think there's any way that Ms. Wint is gonna be able to make a $15,000 bond, Judge.
Yeah.
Ms. Wint, how much of a bond do you think you might be able to afford?
Deportation with 3 kids.
Excuse me?
Deportation with 3 kids.
Are you working?
No.
Does she have a prior record?
Mr. Reedy, Your Honor, and I didn't see anything. Obviously, I would advise the court if there was one.
Well, if she has no prior record, Judge, and she is the mother of 4, again, I would ask the court to consider. You could put a GPS monitor on her, but she's not going to be able to make any kind of a bond from a monetary standpoint.
Okay.
And she's certainly not going to be able to make the bond the state's requesting.
Miss Wint, are you staying with somebody?
No.
And
No.
do you-
My mom have the affidavits, and she leave me on the street for 5 years.
So you currently don't have a residence?
Yeah.
All right.
And, Your Honor, I would just note then, from what you're saying and from what Mr. Reedy's arguing, the children have been with their mother anyway. It's
My mother.
I understand, Mr. Reedy. I guess my concern here is that I don't know that we'd have a way to put a monitor on her at this point in time. I understand. I'm gonna do a $2,000 bond and see if she can bond out with that. You have family here, ma'am?
My kids,
Okay, and are they young or are they older?
7 months old, 14 years old, and 16 years old.
Okay, you have contact with your mother?
Yes, but she don't want any contact with me.
Okay. All right, thank you. Good luck. We're gonna put a $2,000 bond on count 1 and,
Your Honor, I'd also ask for no return to this location.
yes, do no return to this location. Okay, you understand? Don't go back there, all right? Ma'am, you understand? Okay, all right. Thank you. Good luck. All right, Jasmine Greer.
She's here present, Judge, at Maine.
All right. Good morning, Miss Greer. How are you today?
I'm good. How are you?
I'm doing well. You're charged with aggravated assault, deadly weapon, without intent to kill. I read the probable cause affidavit. I find PC.
And, Your Honor,
Yes?
I know she was booked for aggravated assault, but it would appear from the probable cause affidavit, the
battery.
offense, the aggravated battery.
Okay. And does the defense wish to be heard?
Yes, Judge. Judge, once again, I advise Ms. Greer, this isn't her trial date, but she was basically defending herself. She was having some sort of, I believe, altercation with somebody else, and somebody came in and stepped in and basically tried to assault Ms. Greer. But having said that, Judge, like I said, like I explained to Ms. Greer, today is not that day. Having said that, Judge, she's 22 years old. She's been here for almost 18 years. She's working. She works at the Pancake House. She's been there for about 4 months as a waitress. She gets about $5 plus tips. She also has a second job to try and make ends meet, Judge. Now, she lives in Plantation with her father. where they rent at an apartment for the past 5 years. His father is a handyman, so their resources are limited. Judge, we're going to be asking you for a $1,000 bond. She has strong time. She will be coming to court. She's not a flight risk. She's looking forward to defending this case, Judge.
And I understand Mr. Romero has been advised by Ms. Greer. Your Honors had an opportunity to read the probable cause affidavit, which details her claims of self-defense, where the officer also, or the detective notes that there was surveillance capturing the incidents, and he lists why he did not believe she was acting in self-defense. Your Honor, she does have a prior theft. I am going to be requesting a $10,000 bond and no victim contact, based on the allegations that this began when she was the primary aggressor towards a woman that was trying to shop at Publix with her infant in a stroller. This victim came to that woman's defense, and ultimately Ms. Greer slashed him with a knife in his arm.
Well, of course, the court has not had the opportunity to see this video, so we don't know exactly what it shows. This is a probable cause affidavit written by an officer to justify the charges for which Ms. Greer was arrested. So until that video is actually seen and we can actually determine what's on it, I still think that the benefit of the doubt should go to Ms. Greer here.
Unless Mr. Reedy has any statutory case law that says the benefit of the doubt goes to the defendant and not the sworn report and the probable cause affidavit that's presented to the judge, I would ask the court to rely for the factual evidence, to rely on the sworn probable cause affidavit.
As everybody as everybody has eloquently stated, this is, not an adversarial hearing for purposes of determining guilt or innocence, simply to determine whether there's probable cause. There is probable cause. I'm going to find that it should be a $5,000 bond, okay, and no victim contact. I don't know if you know this gentleman or not, but please do not make contact with him, and don't return to the Publix where this all started, okay? All right, Ms. Greer, you'll have your day in court. I understand you're upset. I'm not here to determine guilt or innocence, okay? This is a very simple, straightforward hearing. I read this piece of paper, I gotta make a call as to what's in front of me, okay? Stay in contact with your lawyers. Good luck to you. All right, Angelina Vespia?
All right, Your Honor.
All right.
All right, is it Vespia? Did I say that right?
Yeah, you
All right.
have it right.
Good morning. You are charged,
morning.
you're charged with 1 count of possession of cocaine, 1 count of possession of fentanyl, and 1 count of drug paraphernalia. Having reviewed the probable cause affidavit, I do find that there is PC. There is currently a total bond of $2,100. Mr. Reedy, do you wish to be heard?
Yes, Judge. Ms. Vespia, can you make that bond?
It's a little tight. Like if I had like just the $1,000 and the $100 bond, I know I can make that.
Okay, Mr. Linder?
Well, that's what I'd ask for.
Yeah.
Your Honor, Ms. Vespia, so far this year, she pled out to 2 counts of possession of drug paraphernalia, May 20th of this year. Looks like she just got out of jail earlier this year after violating probation on a possession of fentanyl, that she was sentenced to 90 days in county jail. Another possession of drug paraphernalia, 2018, theft, 2018, also showing on the possession of heroin. She actually had her release revoked in that matter because she was out on that and picked up another drug offense. That was last year.
All right, we're gonna go ahead and do a bond of 500, 500, and 100, all right? So you'll get your $1,100 bond, okay, Ms. Vespia?
Well, is there any way, because when you do it that way, the bondsman still charges $100 per bond. If you put the $1,000 on, say the fentanyl charge or the cocaine charge, and then put no bond for one of the other ones, that's the only way it'll come out to be $1,100.
I think she does have a point, Judge. I think that's the way a lot of bondsmen operate, is they would take $100 for count 1, $100 for count 2. Whereas if you made it a $1,000 bond on count 1, they would take $100. Was that what you're saying, Ms. Vespia?
Exactly, like whether it's 500 or 1,000, they're gonna charge $100 no matter what. So is there any way you can just charge me $1,000 on, say, the cocaine charge, and then charge like ROR for the fentanyl charge, and then $100 for the paraphernalia charge?
That's fine. We'll do 1,000 on the cocaine. or are you on the possession of fentanyl and $100 on the paraphernalia? All right,
Thank you,
good
Your
luck
Honor.
to you.
Judge, you told me to inform the court when Mr. Gray was brought in. He's here, so whenever the court's ready.
All right.
Mr. Gray, come on up, please.
All right, this is page 25, Jonathan Gray.
Correct, Judge.
Good morning, ma'am. How are you today?
I'm good, and you?
I'm doing well. All right, just give me 1 second. We'll be right with you, okay?
Okay.
Mr. Gray, you are charged with 1 count of aggravated battery, that you knew or should have known that the victim was pregnant, 1 count of resisting obstruction without violence, and then you have some, looks like previous warrants here for sale, cocaine, fleeing and eluding at a high speed, resisting officer obstruction without violence, leaving the scene of a crash involving damage to property, operating without a valid driver's license, and there seems to be a capias for an outstanding traffic criminal offense. And you apparently are set for status on one of these tomorrow at 8:30. Okay, having reviewed the probable cause affidavit, I do find that there is probable cause. Ma'am, what's your name?
Quintera Neal.
I'm sorry, say again?
Quintera Neal.
And what can I help you with, Ms. Neal?
I'm the victim in the case on the aggravated battery.
Okay.
I just wanted to let it be known that I don't wish to go further as far as like prosecuting. Yesterday, it was just a heated moment. There was a lot of people around where the police were called out to the scene. As far as the situation with me and him, I mean, I know I'm not gonna go forward as far as pressing charges on him or anything like that. That's my child's father, so.
Okay. Mr.
Your
Leonard?
Honor, that being said, I am still going to be requesting a $10,000 bond and no victim contact. Mr. Gray has a history of violence. 2010, he was convicted of felony battery, great bodily harm, felony battery due to priors, and robbery by sudden snatching. He was sentenced to 3 years in state prison. 2009, he was convicted of aggravated battery with a deadly weapon. He violated probation, was sentenced to 3 years state prison. I'm showing, Judge. Actually, I'm showing a warrant out of, it's pretrial, are you showing a warrant out of the state of Pennsylvania from December of last year? These prior convictions out of Pennsylvania for conspiracy. Looks like that has to do with identity theft and fraud. One moment, Judge. One moment. I'm sorry. Just want to make sure. Your Honor, I'm actually showing that there is the warrant is on a parole violation with full extradition in the United States. And I would ask if pretrial can confirm that if they have the same information. I can tell you on my NCIC hot file alert, it has the same address, same social security number for Mr. Gray. That is listed on the booking sheet. Yes.
So it sounds like he's got a warrant out of Pennsylvania?
There is an active warrant, yes, there is an active violation of parole probation.
Okay.
We'll have to contact BSO to have that served.
All right. Mr. Romero, do you wish to be heard, or Mr. Reedy? I don't.
Judge, yes. I do understand Mr. Gray has a record. We did speak about this, and that's why I'm not asking for the court as far as anything regarding counts 2 through 9. However, on count 1, you have heard from the victim. Judge, as you heard, Ms. Gray is basically telling the court that she intends on filling out a waiver of prosecution. I would like the court, for mitigation purposes, to take that into account. My understanding is, in reading between the lines, I do not believe the alleged victim is in fear. Also, my understanding, the $10,000 bond, which the state has suggested, is something that Mr. Gray nor the alleged victim can come up with. So therefore, considering the probability of this case even going forward or being filed is not likely, Judge. I'm gonna be asking for the court to consider a $2,000 bond on count one.
All right.
Your Honor, my understanding, I've just been advised by, excuse me, by confinement status, that, that warrant is going to be, served on him.
Okay, so, and I'm guessing that seems like a parole violation warrant, so.
It's parole or probation, it wasn't really clear either way.
All right.
Okay.
All right, well, Mr. Gray is going to have a different issue to contend with. That's the warrant out of Pennsylvania. As far as count one, taking into account Ms. Neal, I'm going to go ahead and do a $5,000 bond, a $100 bond as to count two. All right? For the time being, and I understand, Ms. Neal, I heard you. I don't want you to think I'm not taking into account what you're saying. For the time being, I'm going to ask that there's no contact, okay? If this goes back to division, they might request to remove that no contact order. You have an opportunity to go in there, testify again, explain that you're not in fear. But for the time being, based on the recency of this, I'm going to ask that there's no contact at this point in time, okay? So he's not to contact you. Mr. Gray, do not reach out to Ms. Neal. Don't contact her. Don't text her. That all may change, okay? But for the time being, do not reach out to Ms. Neal, okay? All right. And the other bonds are $2,500, $1,100, $25, $25, and $1,000, and then the parole violation out of Pennsylvania. All right, good luck to you, Mr. Gray. Thank you, Ms. Neal. Thank you for coming in today. All right, Leanne Rosenblatt? Sure. We'll set that aside. What about Scott Denny?
Scott Denny? Let me see, Judge. You know what page so I can see what's
It's,
going on with him?
let me see, page 7?
Medical loan, Judge.
Medical loan, okay. All right, what about Jaquez Dillard?
Mr. Dillard, come on up. He's approaching, Judge. You see what I mean?
No?
No, he might possibly use it for medical reset, however, his charge is for out of state.
I saw that.
And, he's been here since June 30th with no extradition hearing, no, so I don't know.
Yeah. Yeah, that's true, Your Honor. See, the problem is if you keep resetting him in here, then it prevents him from being scheduled for his extradition hearing, as opposed to if you make the PC determination, press it along to the clerk, then he could be scheduled for an extradition hearing before Judge Malika.
All right, let me take a step back on Mr. Scott Denny. Mr. Reedy, I know he's not present. I'm sorry, you're on the phone. Do you want me to check with Mr. Romero? I don't want to. No, go ahead. Okay, on Mr. Scott Denny, they're indicating this has been reset over since June 30th. And because he's either on a medical reset or out on loan or some sort of situation and no probable cause determination has been made, they can't set him down for his extradition hearing. Would you have any objection without him being present for me to review the probable cause affidavit, make a determination as to probable cause so that he could get this going in a more finalizing direction?
No, Your Honor, I think we need to move it forward.
All right. With no objection, I'll go ahead and find PC having previously read the probable cause affidavit, and this will go to Judge Malika's division? Is that
Yes,
correct?
sir.
All right. All right, back on Mr. Dillard. I apologize for the interruption, Mr. Dillard. How are you today? All right. You have an out-of-state hold. Not much I can do about that, okay? So we'll go ahead and sign the paperwork and get you going in the right direction so you can get this taken care of, okay?
Good luck, sir.
All right, good luck to you, sir. All right. Mohammed Hamad?
Judge, he's approaching, and he declined the services of public defender.
Okay.
Don't talk about the facts.
Good morning, Mr. Hamad. How are you today?
I'm doing okay. You?
I'm doing well, thank you very much. You are charged with one count of violating an injunction for a protection order for domestic violence. Now, as you may have been told, today is not your trial. We're not here to discuss innocence or guilt. I'm just supposed to read the documentation that's been filed. I've read it already, make a determination whether there's probable cause and discuss what options there are as far as a bond is concerned, okay?
What?
Having read the probable cause affidavit, I do find that there is PC. I'm gonna take a moment to hear from Mr. Linder from the state, and then I'll let you know what the bond situation is, okay?
Hey, thanks, sir.
All right, Mr. Linder?
Thank you, Your Honor. Based on the nature of the allegation.
Come on back, don't leave yet. Just sit tight for a second.
Based on the nature of the allegation and the short amount of time that passed from when he was served to when he allegedly violated the injunction, I'd be requesting a $5,000 bond and no return, no contact.
All right, Mr. Ahmad, the state is asking for a $5,000 bond, okay? You can post the bond yourself or talk to a bondsman to see about working something out to post that bond. The important part of this is that there's currently an injunction for you not to have contact with your mother, all right? As a condition of this case, I'm gonna order you not to have contact with her, okay? You understand that?
Right.
All right.
So, do you know, like, do I gotta go through a trial, or do I, like, am I gonna get time served? I'm just trying to get time served on this case, or so I can go home and stuff.
I understand what you're saying, so here's the situation.
Get out of jail, you know what I'm saying?
I understand what you're saying. Here's the situation. There's not an offer at this point in time to resolve this case. This isn't the courtroom where you're gonna do that. You'll have an opportunity to have a trial or resolve this case if you want, once this case gets set in front of division. You're gonna be given a court date, okay, sir? You need to be there at that court date. For now, the only thing I'm doing is determining whether there's a bond and how much that bond is. I've determined there's probable cause, and the bond is gonna be $5,000. As I indicated earlier, you can post that, you can have a friend of yours post it, a family member, you can contact the bondsman and see about getting it posted that way. The important part is, on top of posting your bond, is that you do not have contact with your mother, okay? Do not call her, do not text her, do not email her, don't contact her through social media, don't tell somebody to contact her on your behalf. Do you understand?
Right, sir.
Okay. Good luck to you, sir. Thank you.
Because of the charges, you can't contact her.
All right. Wendy Preble?
Mr. Prevel is here
Prevel.
present, Judge. He has private counsel, Michael Glasser.
Okay. Good morning, Mr. Preble.
Good morning.
All right. And we have you charged today with domestic violence, battery. I've reviewed the probable cause affidavit. I do find that there is probable cause. Mr. Linder?
Your Honor, based on the level of violence alleged in this case, the state will be requesting a $2,000 bond, no victim contact.
All right. Mr. Preble, they're asking for a $2,000 bond and no victim contact, okay?
Yes, sir.
All right. What that means is do not make contact with the victim in any way, shape, or form. You might have heard me tell a few others before you. No social media, no email, no text messaging. Don't have somebody contact the victim on your behalf, okay? Don't have them relay a message for you, okay? That'll just get you into more of a situation. You understand?
Yes, sir.
All right. Good luck to you.
All right, thank you.
Charles Perez?
Judge, he's here present. He's going to require a Spanish interpreter. I believe my colleague contacted one.
Okay. All right, we'll put it on a brief recall until the interpreter's here. All right. What about Cleomen Jean-Pierre?
He's here at Main, Judge approaching. Come on up, sir.
Good morning, Judge.
Good morning, how are you today, Mr. Jean-Pierre?
I'm all right, and yourself?
I'm doing well, thank you very much. You are charged with one count of an aggravated battery with a deadly weapon, domestic violence. All right, having reviewed the probable cause affidavit, I find probable cause. Mr. Linder, do you wish to be heard as to bond?
Yes, Your Honor, just one moment, please. Your Honor, I'm going to be requesting a $7,500 bond based on the allegations, also noting Mr. Jean-Pierre was arrested last year for a domestic violence battery against a different alleged victim. The charge was dropped. Also would be requesting a no victim contact order, nothing further.
Okay, Mr. Romero, do you wish to be heard?
Judge, under the circumstances, that's reasonable, so we have an agreement with the state.
All right, we'll go ahead and it'll be a $7,500 bond, no victim contact. Mr. Jean-Pierre, you may have heard me indicate earlier to others, okay, that means don't call, don't text, no social media of any kind. Don't have somebody else contact the victim on your behalf, okay? No passing messages through a third party, you understand that?
Yes.
All right, good luck to you.
Good luck, sir.
All right. Jose Rafael Arrenchia,
Medical loan, Judge?
all right?
This one's messed up.
Yeah.
Kill the victim's kid.
Thank you, Shirley. All right.
And here, history.
Ciodine Casimir?
Medical research, Your Honor.
Okay. Are you guys is that close enough? Are you able to get them? Okay.
No, you
Yep.
can read that one if you want.
All right, Ronald Watkins?
Check this out.
No problem, Your Honor.
These are all against the same victim.
All right, good morning, Mr. Watkins.
Good morning.
All right, you are charged with one count of aggravated assault with a deadly weapon, domestic violence, aggravated stalking, following harassing, cyber stalking, and trespass on property armed. Having reviewed the probable cause affidavit, I find that there is probable cause. Mr. Linder, do you wish to be heard as to a bond?
Yes, one moment, Your Honor. Thank you, Your Honor. Your Honor, based on the allegations in this case, I have a great concern for the safety of the alleged victim and the community. I'm going to be requesting a $50,000 bond on count one, a $25,000 bond on count two, a $1,000 bond on count three. Because of the allegation of aggravated stalking, I'd be requesting pretrial release with a GPS monitor, an order of no victim contact, and no possession of firearms, weapons, ammunition until further order of the court. I would note, in 2017, Mr. Watkins was arrested on a domestic violence battery against a different alleged victim that was dropped. Disorderly conduct, 2012, resisting without violence, 2012, resisting without violence, 2011. Nothing further.
All right, hang on one second, all right? I'll hear you out. Mr. Reedy, do you wish to be heard?
Yeah, Mr. Watkins is not going to be able to afford that bond, Judge. How much bond can you afford, Mr. Watkins?
Sir, I have a couple $100 in my property. Like,
So
that's all I have. I don't have that much money, like to $50,000 bond, and I can't afford that. And I have a daughter, and that's my first. This is my first. This is my first charge. Like I never been convicted of any felonies, and I can't afford that.
You working?
No, sir. I'm not working at all.
Do you have a place to live?
Yes, I stay with my mom right now.
Is Mom going to be able to post any bond for you?
No, she's on Section 8. She can't afford it. I'll be sitting duck, sir. I can't afford that, sir.
Judge, in light of the fact that Mr. Watkins does not have an extensive criminal history, I'd ask the court, and he does live with his mom, I'd ask the court to consider pretrial release with no contact with the victim.
Thank you, sir.
Well, that's not up to me. Don't thank me yet.
I read the probable cause affidavit, and I echo the concerns by Mr. Linder. What I'm gonna do at this point in time is 25,000, 1,000, pretrial release GPS monitor. Mr. Watkins, that doesn't mean that's how it's gonna stay. You'll have an opportunity to be heard once you get to division, okay? They can look at lowering your bond at that point in time, all right?
But sir, how much? I can't afford that. So I basically got that bond right now.
Yes, sir. At this point in time, it'll be 25,000, 1,000 with a pretrial release GPS monitor. No victim contact, no possession of firearms, ammunition, anything like that, okay? Good luck, sir. 25, 25, and 1. Yep. All right. Alton Harris?
North Broward, Your Honor. Mr. Harris is hearing impaired and he does not speak.
Okay. All right, is Mr. Harris able to hear me at all, or do we need a sign? You're able to hear me? Okay, all right.
Your Honor, our experience with Mr. Harris, and this was actually mentioned to the court yesterday, that if it's written down for him, what is being said, or if there's an offer, for instance, and it's written down, he can understand that. I believe he can read lips, but I think there's an issue with that while he's there. And normally what we've done in the past is reset it, with Judge Powell's reset it, to have him brought before the assigned judge the next day. That's a little difficult this week with all the
I was
county
waiting
court
for a
judges
call
away.
back from her lawyer. If we don't hear from him in a
So
few minutes, I'll ask the
how would we
judge
like to
recall it.
proceed? I want to make sure that Mr.
Okay.
Harris has an opportunity to understand everything that's going on here today.
Of course.
Is there a way to reset it for this afternoon and have him here?
That I couldn't answer. That would be, a matter of whether North Broward would be able to have that transport done.
How do I find out if we can get that done?
Brian. Judge wants to know if you want to inquire, call North, see if they could have Mr. Harris brought here this afternoon.
Brought where? To the courtroom?
Yes.
I know Judge Tudor is doing magistrate this afternoon.
Hey, Deputy.
All right, they're gonna let us. All right, we're gonna place this on a brief recall. And Mr. Harris will, I don't know if you can hear me. If you can, we're gonna see you in a few minutes. And I'm trying to see if we can have you brought in here today so we can make sure everything is conveyed to you properly. If Mr. Harris doesn't understand what I'm saying, if someone could just write him a brief note explaining to him that we're gonna recall the case into.
He understands, Judge. He
I'm
just
getting the
gave you
impression he understands.
Thumbs up there, so.
All right, you're hearing me? You understand what I'm saying? Okay. I understand you can't talk. So we're gonna set this on a brief reset. We'll see you in a couple minutes. I'm trying to get you brought here so that you can be in front of a judge this afternoon, so they can write everything out for you, and you can write back any response that you'd like, okay? All right, thank you, sir. We'll see you in a few minutes. All right. Thomas Wright?
Mr. Wright is approaching, Judge, here at Maine.
Okay. Good morning, Mr. Wright.
Good morning, Judge.
All right, you're charged with one count of trespass on a property, not structure or conveyance. There's a $25 bond at this point in time.
Judge, it's me, Mr. Wright. He wishes to resolve this matter. We wanted to see if the state had a plea offer.
An adjudication, time served, no return.
Is that agreeable?
He wishes to accept the state's offer, Judge.
All right. Mr. Wright, you understand you have the right to go to trial to defend yourself against this case, cross-examine witnesses, call witnesses on your own behalf, and all that stuff that comes with it? Or, yes, I didn't hear you, I'm sorry.
Yes,
Okay.
Your Honor.
And you want to waive those rights to resolve this case today for an adjudication,
Yes.
credit time served? All right.
Yes, Your Honor.
Okay, we'll go ahead and accept your no contest plea of adjudication, credit time served. You all set? Good luck.
Good luck, sir.
All right. Grant Harvard?
Mr. Harvard, come on up, please. He's approaching, Judge.
All right. Good morning, Mr. Harvard. How are you today?
I'm all right.
Good. All right, Mr. Harvard, you have a operating with a suspended driver's license, capias, with a $1,000 bond at this point in time. Previous probable cause. Mr. Linder, do you wish to be heard on this?
I've nothing to add.
All right, Mr. Romero, it looks like there's a bond on this for $1,000.
Yes, Judge. What I'm going to be asking the court to consider is an ROR on Mr. Harvard's behalf, and this is the reason why. My understanding, Judge, he didn't know of his court date. He said he'd been going to the clerk of court's website, checking on it to see if he had a court date coming up. He earlier this year got into a payment plan to try and get his driver's license back. He said he did manage to get his driver's license back, but unfortunately 2 weeks ago, it was suspended again. My understanding is when he entered the payment plan, he was paying about $35 a month. He was arrested, I believe, about a month ago for a municipal ordinance, and that caused him to lose his job. And when he lost his job, he can no longer afford to keep up with the payment plan, and then it was suspended. My understanding, Judge, is right now, he lives here locally. He wants to.
I'm gonna ROR him.
try-
Your Honor, there's some additional information the court should be aware of.
Oh, okay.
This Acapius was issued June 24th. I'm looking at a court notice dated March 25th, where he was given in open court his court notice to be in court June 24th. He knew he was supposed to be in court.
Does he have
June
any other
24th.
failure to appears on any other cases?
He was arrested earlier, actually, I'm sorry, he was arrested last month on Acapius on a municipal ordinance.
Do we know
And
what?
that was the,
Yeah, I never had to go to court.
that was the municipal ordinance, I believe, I told the court about it.
Only thing I got.
I'm just concerned, Your Honor, because he's representing Mr. Mayor that he was checking the clerk system.
Well,
He was handed in his hand a notice telling him when to be in court.
I understand. Do we know when the future court date on this would be?
Oh, no, if he's ROR'd, no.
The clerk's office will go ahead and set up a court date for him, and then he wants to try and get his driver's license back so that he can present it to the state attorney in the courtroom.
Is there any way to find out when his court date would be? On Mr. Harvard, Grant Harvard?
We wouldn't know because once the paperwork is saying that he was case served, it goes to the north-south line. And then the north-south line is in the north-south line.
Mr. Linder, your arguments are well taken. I understand. I'm going to go ahead and ROR him. Mr. Harvard, listen carefully, okay? Every time there's a misunderstanding like that, what ends up happening is it goes into the court file, okay? And this time I'm giving you the benefit of the doubt that there was a misunderstanding, that you were trying to find your court date, and you missed it. You miss it next time, it might not be, it might not work out this way. You understand?
All right, thank you, Your Honor.
Okay, no driving, okay? While your license is suspended.
Until you get a valid driver's license.
Okay, got it.
Good luck.
What about Marcandy Joseph?
Mr. Joseph is here present, Judge. Mr. Joseph, come on up, please.
Just give me 1 second, Mr. Joseph, I apologize. All right, sorry about that, Mr. Joseph. All right, you have one misdemeanor capias, looks like operating without a valid driver's license. It has a $500 bond, probable cause. Anything else I need to know?
Judge, he's asking if the court would consider resolving this matter. We want to see if the state had a plea offer.
Mr. Linder?
Checking right now. The pending offer from the state is a withholding court cost.
Withhold court costs.
He wishes to accept the state's offer.
All right. Mr. Joseph, you understand that by accepting this plea, you're giving up your right to go to trial, have a trial in this case, call witnesses on your behalf, cross-examine witnesses, appeal the case, all those rights that you are entitled to, you're giving up those rights to resolve this case today?
Yes, Your Honor.
All right. We'll go ahead and accept your no contest plea, and it'll be withhold court costs. You're all set. Good luck to you, okay?
Good luck.
All right. Freddie Serrano?
He's approaching, Judge.
Okay. Mr. Serrano, good morning. How are you today?
Good morning. Great.
Good. You're charged with one count of operating without a valid driver's license. There's a capias warrant for you, $500 bond. Anything we need to know? Anything else in regards to this case?
Mr. Serrano wishes to resolve the matter, Judge.
Okay. Mr.
Offer
Linder.
would be adjudication, time served. Court.
Adjudication, credit time served.
He wants to accept it.
Yes, sir. Yes, sir.
All right, Mr. Serrano, you heard me mention this to a few others before you, okay? You understand you're giving up your right to go to trial, you're giving up your right to defend yourself against this case, call witnesses on your behalf, cross-examine witnesses, appeal the case, all that good stuff? You're giving up
Yes,
those
I do.
rights to resolve this today?
Yes, I am.
Okay, we'll go ahead and enter a no contest plea on your behalf, adjudicate credit time served. Good luck to you, sir.
Hello.
Matthew Oates,
He's approaching Judge here, Maine.
okay?
He's approaching, Judge.
Good morning, Mr. Oates, how are you today?
I'm well, sir. How are you, Judge?
Doing well. You're charged with one count of trespass. There's a $25 bond. I find probable cause. Mr. Romero?
Judge, in speaking Mr. Oates, he advised me he wanted to resolve this matter today.
Mr. Linder?
Offers to withhold court costs, no return.
Withhold court costs, no return to location. Is that acceptable?
He wishes to accept the state's offer, Judge.
All right, you understand by entering a no contest plea, you're going to resolve your case today. You're not going to have a trial. You're not going to defend this case, call witnesses, cross-examine witnesses, appeal this case, any of that. Any of those rights you're afforded, you're giving up those rights to resolve the case today?
I accept that.
Okay, we'll go ahead and do withhold court costs and resolve your case. Okay, good luck to you, sir. No return, I'm sorry, yes, no return. All right, what about Gablin Filsami? I don't know if I pronounced that correctly.
He's here present, Judge Maine.
Good morning, sir. How do I pronounce your last name? I want to pronounce it correctly.
Filsame.
Filsame?
Yes.
All right, good morning, Mr. Filsame. How are you today? All right. You are charged with one count of trespass, occupied structure or conveyance. There is a $100 bond. Mr. Romero?
Judge, he just advised me he wanted to resolve this matter.
Mr. Linder?
Adjudication, time served, no return.
Adjudication, credit time served, no return to location. Is that acceptable, sir?
That's good.
All right.
Yes.
You just heard me speak to a few others before you, okay? You understand you're giving up the rights you have on this case to take this case to trial, cross-examine witnesses, call witnesses, appeal this case to a higher court. You're doing all that because you want to accept this today?
Yes.
All right, we'll go ahead and adjudicate credit time served, resolve your case, enter a no contest plea on your behalf. Good luck to you, sir. Tommy German?
He's coming up, Judge, Mr. German.
Good morning, Mr. German. How are you today?
Good morning, sir.
All right, you are charged with one count of trespass. There's a $25 bond. I find probable cause. Mr. Romero?
Your Honor,
Judge,
Yes.
he wishes to resolve the matter.
Hang on, one second.
Mr. German is currently on pretrial release in a felony case, 19002526 CAF 10A felony petty theft. At this time, we're requesting a revocation of his supervision.
Okay. Mr. Romero, they're requesting a revocation of his supervision. He's out on pretrial release on a previous case. They just read the case number into the record, 192526 CF 10A. Do you wish to be
Judge,
heard?
how long has he been out on pretrial in that case?
February 26, 2019.
Since February.
Judge, at this time, I'm going to ask the court not to take any action. My understanding is, I just spoke to him, I believe there's been no other violations of pretrial. He's been out since February. The new law offense right now that he's picked up is a misdemeanor trespass. At this time, I don't feel comfortable in resolving the new law offense. I'm going to be asking the court not to take any action on the case that he's on pretrial, but if the court is inclined to take any action, I'd ask the court, rather than holding him no bond, I'd ask the court to consider something least restrictive other than holding him no bond. As the court is aware, no bond hold would be the most severe sanction or pretrial sanction this court can impose. I'd ask the court to consider a less alternative, either one, potentially a level 2 with a monitor, or imposing a monetary bond on that case that he's currently out on, Judge.
Mr. Linder, do you wish to be heard?
I'll leave it in the court's discretion.
All right. Can you afford a $2,000 bond?
Judge, Judge, he just advised me he's homeless, he doesn't have anything.
I understand.
So on level 2 pretrial, you'll be stuck in here anyway.
Right, I was just,
Unless we can supervise him on it.
yeah, there's not a whole lot I can do. All right, it'll be a $2,000 bond. I apologize, Mr. German, I understand you're in a tough situation at this point in time. I just have very few options. If you have a friend or family member that can post the bond for you, okay, you can get out. All right.
And you do have plenty of options, Judge. You don't have to revoke his pretrial release. You can leave him out on pretrial release. You can even resolve this case. So your options aren't limited to what pretrial release recommends. It's up to
understand.
you what you want to do.
No, I got that, but Mr. Romero doesn't want to resolve the current case because of the pending case. So we're just left with whether we're going to revoke or not,
Okay.
right? Is that correct, Mr. Romero? You don't want
Judge, if the court were inclined not to take any action or after the court accepts his plea, to basically reimpose standard pretrial, I mean, that's something we would certainly be open for and Mr. German would want, but if the court's inclined to take action on the case he's currently out on, I see where at this point resolving the trespass really is not too beneficial for Mr. German.
to? What's the situation with the felony charge that he has, Mr. Linder? I see here it's a felony petty theft?
Yes, Your Honor.
Does he have any other priors?
1 moment.
4. Okay. Okay, sounds good.
(2017) theft, 2012 grand theft auto, 16 months state prison, 2008 delivery of cocaine, burglary of a structure, resisting without violence, a little under 15 and a half months state prison, possession of cocaine 05, possession of cocaine with intent 04, possession of cocaine 04. Goes on from there, mostly drug priors.
All right, I was, Mr. Romero, Mr. Reedy, I was looking to see if there was another option based on the.
I understand.
Based on the priors, I'm gonna go ahead and revoke. It'll be the $2,000 bond and find probable cause on the other case.
And, Your Honor, just to let you know, we have the Spanish interpreter.
Yes, the Spanish interpreter is present.
All right, Mr. German, good luck to you. All right, and that was on Perez, correct?
Yes, sir.
Good morning, Your Honor.
Good morning, how are you?
Good.
All right, great. We have Mr. Perez, Jaime Perez
He's a person,
Chavez?
Judge, he's on page 9 of the docket.
Yes.
Sheila, she may be charged. Immigration. What's that? Or at least it's not on the booking.
Good morning, Mr. Perez. Let's have.
Good morning, how are you?
Yeah, let's have the interpreter sworn in. Do you swear or affirm to translate from Spanish to English and English to Spanish to the best of your ability?
I do, Your Honor. For the record, that's Igor Felicion.
Okay. All right. Mr. Perez, you are charged with 1 count of domestic violence battery.
Señor Pérez, se le acusa de un cargo de violencia doméstica, agresión física.
And you have 2 capias warrants for DUI and operating without a valid driver's license.
Y tiene 2 cargos, 2 órdenes de captura por manejar bajo los efectos y manejar o operar un vehículo sin una licencia válida.
And you also have an immigration hold.
Y también hay una retención por inmigración.
I've reviewed the probable cause affidavit and find that there is probable cause.
He revisado la declaración jurada de causa probable y he efectuado el hallazgo de que efectivamente hay causa probable.
You also have a $1,500 bond on each one of the 2 capiases.
Por cada una de las 2 órdenes de captura, usted también tiene una fianza de $1,500 cada una.
Mr. Linder?
Señor Linder?
Your Honor, also, I don't know if it's on the findings, it's on the docket, but not on the booking sheet. I'm sorry, I didn't catch, nothing,
Okay.
nothing on that. Your Honor, based on, I'd be requesting a $3,500 bond and no victim contact.
Su señoría, basado en la información, estaría solicitando una fianza de $3,500 y una orden de abstenerse de contactar a la víctima.
This is based on the allegations, information provided by the victim that there's been previous and ongoing violence by the defendant against her.
Esta solicitud es basada en los alegatos y en el documento acusatorio de la víctima, quien sostuvo que han habido episodios sostenidos y previos de violencia entre ellos dos.
I'd also be requesting an order of no victim contact, nothing further, Judge.
En este momento también solicitaría una orden de abstenerse de contactar a la víctima y más nada en este momento, su señoría.
All right, Mr. Romero?
Señor Romero.
I did advise Mr. Perez that the court would be imposing a no contact order. He says he will abide by that court order.
Okay.
Yo le notifiqué al señor Pérez de que la corte iba a emitir una orden de no contactar a la víctima y el señor me indicó que él iba a obedecer esa orden.
All right.
Now, he works in landscaping, Judge, and he makes approximately $120 a day, and the person he's going to be relying on, his brother, also works in landscaping as well.
Él trabaja en jardinería, hace $120 al día. La persona con quien él va a estarse apoyando es su hermano que también trabaja en jardinería.
Now, Judge, my understanding, he's never been arrested on a domestic situation in his life.
Entiendo que él nunca ha sido arrestado por una situación de naturaleza doméstica en su vida.
So based on that and based on the fact that this is a misdemeanor offense, I'm going to be asking for a $1,000 bond on Mr. Perez's behalf.
Basándonos en eso y en que esto se trata de un delito menor, voy a solicitar en este momento una fianza de $1,000 para el señor Pérez.
Is there any priors outside of the DUI, Mr. Lind?
Fiscalía, ¿él tiene algún antecedente aparte del cargo de manejar bajo los efectos? Un momento, su señoría.
I'm not showing anything previous in Broward.
Okay.
No veo nada anteriormente en el condado de Broward.
All right, it'll be a $1,000 bond, no victim contact.
La fianza queda fijada en $1,000 y no podrá tener contacto con la víctima.
Mr. Perez, you are not to contact the victim.
Señor Pérez, no deberá contactar a la víctima.
Don't call, don't text, no email, no social media.
No podrá llamarla, no podrá enviarle mensajes de texto, no podrá enviarle correos electrónicos, no podrá contactarla a través de redes sociales.
Okay. Do not have anybody contact her on your behalf.
Y tampoco le pida a terceros que la contacte en su nombre.
You understand?
¿Me entiende? Yes.
All right, good luck to you, sir.
Buena suerte a usted, señor.
Judge, would you sign a phone order as well?
Yes.
¿Su señoría pudiera firmar una orden de acceso al teléfono? Sí.
All right, we have Scott Allen.
Your Honor, are there more Spanish interpreter cases?
I am unaware of any others. Do you know of any, Mr. Romero?
¿Alguien solamente habla español? ¿Solamente habla español?
No one else here at Main, Judge, requires a Spanish interpreter.
Okay.
I don't know if the other facilities though.
All right, do we know at Paul Ryan, Conti, or North Broward?
Not as far as I know,
Broward's
Judge.
North Broward's good. And Mr. Reedy, you indicated.
Paul Ryan is good, Your Honor.
Paul Ryan's good. What about? That's it? All right, thank you.
Your Honor,
Yes.
can we take Mr. Stinson on page 32 out of order? His lawyer's here actually to see him, so we can do his ad charges and get him down to his lawyer.
Sure, absolutely.
And I already called Mr. Reedy, and Mr. Harris will be on his way down for you for 1 o'clock. Maybe we can get him down here sooner, depending on transport.
Okay, fantastic. So it looks like we will reset Mr. Harris for this afternoon unless he gets down here any earlier, and
I will call as we get closer to the end of the docket to see if he's here. I'm not overly optimistic we'll get him this morning, but we should have him this afternoon.
I'm not, but I'm guessing he'll be here this afternoon. I won't be here this afternoon. It'll be Judge Tudor, but I'm sure y'all will explain to him what happened and why we reset this for this afternoon, so that, and I'm sure he will be able to deal with it. All right, and Mr. Stinson is,
North Broward.
yes. Good morning, Mr. Stinson.
Good morning, sir.
All right. Okay, and my understanding, these are change of charge?
It's two change of charges and an ad charge, if I can go through them one by one, Your
Sure.
Honor. Count one, the attempted first-degree murder. That is
Free pickup and magistrate.
That is actually an upfile. I provided the court with the original findings by Judge Powell, the information that the state filed, and the applicable probable cause affidavit. As you can see, when Mr. Stinson was first arrested, he was charged with attempted second-degree murder. It's been upfiled to attempted first-degree murder.
Okay,
On charge 4, that's really a technical change of charge. Because they can't book him in the jail for attempted murder, it was booked for murder. It was always attempt. That's what Judge Powell found proof evident or presumption grade for. As you can see in the findings, it was for attempted murder and ordered him to be held no bond. There was never an allegation that,
so that's just, all that they did here is to count 4 was just
it's a technicality.
technicality, all right.
And charge number
100 bricks.
8, the shooting into a vehicle is an ad charge. So that would be a matter of first impression for this court.
All right.
On the, and it's really a technical, obviously on the attempted murder of a law enforcement officer, I just asked that the court adopt Judge Powell's original findings since she found proof evident for the same offense he's before the court on, and keep the no bond hold in place on that count. On the attempted murder of a civilian, Your Honor, I provided the court with the probable cause affidavit. I would be asking, now that he is charged with a punishable by life offense, that the court make a finding of proof evident or presumption great for first appearance purposes only, and that he be held no bond, and that, I believe the defense already filed a motion for an Arthur hearing in front of the assigned judge. It would just include that charge as well.
All right, and what are you asking for as to the ad charge?
Based on the other bonds that have been set, Your Honor, a $10,000 bond on the shooting.
The court will go ahead and accept the findings of Judge Powell as to count 4. That's going to remain no bond. As to count 8, that'll be a $10,000 bond. As to count 1, the court will find proof evident presumption great and will enter a no bond hold. And this is, you said they've already filed as to having a hearing in front of division, correct?
Yeah, I checked Odyssey this morning, and it showed that an Arthur motion was filed to seek an Arthur hearing.
Okay. All right, perfect. All right, Mr. Stinson, my understanding is that your lawyer is here to see you, so we won't hold you up anymore. There is some new information you may want to pass along to him regarding these changes and adds of charges. Just make sure that they have an opportunity to look at that, okay?
And Your Honor, I'm sure his attorney's going to advise Mr. Stinson, but just so he can be aware now also, he is scheduled for arraignment next Tuesday morning before Judge Fine at 8:45 in the morning.
All right, so you've got court set next Tuesday morning, okay, Mr. Stinson?
Yes, sir.
All right, good luck to you, sir. All right,
Thanks, sir.
Judge, do you want to recall Miss Rosenblatt on page 6?
yes. And that was where?
She's in Paul Ryan.
All right. All right, we're on Miss Rosenblatt.
Yeah, I've been trying to reach her attorney, Judge, with no success today. The count before us is burglary of a conveyance. Ms. Rosenblatt currently has a $50,000 bond on count 4, which is not before the court this morning. So I'd ask the court for a $1,500 bond on count 1. And she can go before her division judge and address all of her other bond issues. Obviously, it's count 4 is the big one that she needs to worry about.
And Your Honor, frankly, if it gives the court comfort, I checked. The original charge was also a burglary conveyance. This is really more of a technicality. So the state was going to be requesting that the $1,500 bond be kept in place that was originally.
All right, that's fine. So everything's basically going to stay in place, Mr. Rosenblatt. Nothing's really changing. There's just some technicalities they needed to take care of as far as the filings are concerned. All right, so the bond will stay at $1,500 on this count, okay?
Okay,
All right, good luck to you, ma'am.
thank you.
Find probable cause. All right. Michael Cade,
Medical research, Your Honor.
all right.
Warner.
Jameel Warner,
Lil Brown.
Did we call Scott Allen, Your
Oh,
Honor?
you know what? I set that aside. Sorry. Let's do Mr. Warner since we called it, and then we'll go back to Scott Al. All right.
Stinson, Harris.
All right, Jameel Warner. Good morning, Mr. Warner. How are you today?
Okay, sir.
All right, you are charged with one count of petty theft. Seems like it's a third subsequent offense. Having reviewed probable cause, I find probable cause. Is this an ad charge? Is that what this is? I
It
see
is.
it as a count 4.
Yes, Your Honor, it is. And he's
There's
got 2 no bond holds on VOPs. I was not gonna request any bond increase.
But I've been here already for over 45 days.
I
And they
understand.
ain't filed a charge.
I understand, sir. So you're being held on what is violation of
A
probation?
theft and 2 separate felony VOPs. Your
You've
Honor.
got 2 felony violations of probation that are holding you in. This is an ad charge. You're not asking for anything in regards to,
No, I'm fine with the bond being kept at $750.
there is a bond on here for $750, okay? But this isn't the one that's holding you up.
Okay.
All right, good luck to you, sir.
So what is this? What is this about?
This is an ad charge onto one of your cases for a theft, all right? And they changed it to a third subsequent offense, it looks like.
Okay.
Your Honor, just so
Yeah,
Mr.
it-
Warner's aware, it allegedly occurred 4 days prior to his arrest.
There you go.
It's back from May 22nd, Mr. Warner.
All right?
Another charge?
Yes, there's a bond on that one for $750, sir, okay?
Yes.
All right. All right, let's go back to Mr. Allen.
Yeah, no.
Scott Allen?
Scott Allen is a medical, he refused, Your Honor, I'm sorry.
Your Honor, this would now be the 3rd straight day that Mr. Allen has refused to come to court. I would ask that the court make a probable cause determination at this time.
And Mr. Linder, he's also on the PM docket second.
What does that mean?
And I'll bring that to Judge Tudor's attention if he refuses, but her first appearance, I mean,
Okay. Got
yeah.
it. All right. Go ahead and enter probable cause.
Okay.
All right, and Antoine Ricks?
No
And we'll try
problem.
Friday.
All right, Mr. Ricks, good morning. How are you, sir?
All right.
All right,
Okay,
sir,
sounds
you
good.
have
We'll set up
a
for Friday.
capias on possession. This is in front of Judge Merrigan.
Sounds
There's a
good.
$1,000
Okay, you got
bond.
That's a mistake, Your Honor.
Your Honor, he should be ROR'd on this charge. What happened was he was arrested on a possession of PVP. He's being held no bond on the other count. While he was in custody, the defense filed a motion for release when the state had not filed an information. The motion was granted. Since then, the state filed a change of charge for possession of Utilone.
So this should be an ROR.
But yeah, because he has not committed any new law offense or not missed court, it should be, the ROR should be kept in place.
All right, so I'm gonna enter an ROR. At this point in time, you'll be released as to this charge. I don't know if you have anything else holding you in, okay, sir?
All right, thank you.
Good luck to you. Kimon Miller?
He's approaching, Judge, you hear me?
Okay.
Come on up, sir.
All right, Mr. Miller, good morning. How are you today?
Good.
All right, you have one charge of grand theft and one charge, these are ad charges, one charge of grand theft, one charge of obtain property by false person or personation, I'm sorry, and there is a bond of $1,000 on each count. Find probable cause, anything else that needs to be,
Your Honor, Mr. Miller has a
one at a time, hang on. Let me hear from Mr. Linder, then Mr. Romero.
Your Honor, Mr. Miller has a $3,500 bond on count 1 for robbery by sudden snatching, so I'm not gonna be making any requests for modification. Only thing I'd request is an order of no victim contact, Your Honor.
Okay, Mr. Romero?
Judge, no objection as far as no victim contact, but as you heard from the state, I believe he's been in custody now since July 4th on a robbery offense in which he has a $3,500 bond. He has family that he's reached out to. His brother right now is saving up his weekly paychecks in order to bond him out. My understanding, his brother works at Arby's. Mr. Miller, unfortunately, he has no funds to post his own bond, so he's relying on his brother. Judge, these are two ad charges. What I was going to ask you, considering I know the court can't take any action on the other case, but I was going to ask the court to consider reducing these bonds to $500 so that it could be that much easier for his brother to post his monetary bond. But as you heard, most bondsmen, they go by the count, so they take 10% of whatever the amount is per count. So I was going to ask then, I was going to ask for a total $1,000 bond, so I'm asking $1,000 bond on count 2 and ROR on count 3.
And Your Honor, the reason, while I'm not asking for a bond increase, the reason I'm asking that the bonds be kept in place, the robbery by sudden snatching, it's pretty much the same fact pattern, except he set up with the victim to buy her iPhone over an app or website. When she arrived at the Publix, essentially he and his co-defendant, they snatched the phone from her possession and took off running.
Okay, but that count is the one with the $3,500 bond?
Yes, sir.
All right, so we'll do 1,000 on count 2, and we'll ROR on count 3. All right, good luck to you, Mr. Miller. Yes, I'm sorry, Mr. Miller, no victim contact, okay? Do not reach out to that person, do not call that person, do not contact them, no social media, no texting, don't use any other person to contact them, you understand?
Yes, sir.
All right, good luck to you. All right, Hudson Adrian,
At Your Honor. Yes, sir.
where at?
Yes, Your Honor.
Oh, here we go, okay. All right, Mr. Adrian,
Yes, sir.
good morning, how are you today?
Not so good.
Okay, I understand. So you currently have an immigration hold, not a whole lot I can do about that, okay?
Yes, sir.
All right, you understand? So we'll go ahead and sign the paperwork and we'll see what happens. Good luck to you, okay?
Is my case been, the DUI case been dropped or?
Sir, truthfully, I have no idea. The only thing I can tell you is what I have in front of me, and what I have is that you have an immigration hold at this point in time, okay?
So I'm waiting on the immigration.
Yes, sir.
All right, thank you.
Good luck to you. Tamaris Higgs?
He's approaching Judge here, man.
Good morning, Mr. Higgs. How are you today?
I'm fine, Your Honor.
Okay. You also have an immigration hold. There's not a whole lot I can do about that. You understand?
Can I ask a few questions? One moment, Judge, let me first.
Yeah, I was gonna say, speak with Mr. Romero first.
We're ready to proceed, Judge.
Okay. All right.
Nothing, Judge.
Nothing, okay. Thank you very much, Mr. Higgs. Good luck to you.
Okay.
All right. Larry Andrews? Good morning, Mr. Andrews. How are you today?
Hoping for the best.
Okay.
Thanks for asking.
I understand. You are charged with one count of grand theft, one count of operating without a valid driver's license. I find probable cause the grand theft has a $1,000 bond, and the operating without a valid driver's license, there's nothing on here, so I don't have a problem with that being ROR'd unless Mr. Linder's gonna tell me something I haven't heard of.
No.
No. All right, we can ROR count 2. Anything else, what's that?
Judge,
Whatever's easiest.
He has $1,000 bond.
We'll leave it as an NC, that's fine.
Judge, he has $1,000 bond. I see the standard bond. I advise Mr. Andrews if there's anyone that can afford to post his bond. Unfortunately, at this time, no one can afford to post his bond. He's been here his whole entire life. He's 25 years old. He does work. He works at a labor pool, so Judge, depending on if there's work, it can fluctuate from day to day. You can get $60 to about $80, $100 a day. He lives in Pompano Beach with his aunt. His aunt works in the cafeteria of a school, and she, at this point, cannot afford to help post his monetary bond. Now, he does have prior contact with the criminal justice system, but I believe it's been a couple of years. So, Judge, I'm going to be asking on this nonviolent offense if the court would consider releasing him under supervision of pretrial release.
I have no objection to pretrial, Your Honor.
Pretrial release it is, as to count 1, okay? So you'll be out in a little bit, Mr. Andrews, okay? Good luck to you.
You have to report there. If you don't report there, there's going to be a warrant issued for your arrest. Make sure you report there. Follow the map, okay?
All right.
As soon as you leave. If they're closed, you have to report tomorrow morning, okay? Okay. Go.
Gregory Lee?
Mr. Lee, come on up, please. Judge, he's here and he declined the service of public defense.
All right.
Yes, Judge, I spoke with his attorney, Mr. Hagens. He's aware of the situation and is asking the court to leave the $750 bond in place.
All right. So, Mr. Lee, there's We're gonna leave the $750 bond in place. You also have a violation of probation, and then you've got what looks like a couple of traffic infractions. I'll go ahead and find probable cause. Your lawyer's aware of what's going on, okay? I'm sure he'll be in contact soon, to help you, go about the process with this, okay?
All right,
Good luck to you.
thank you.
Deleon Johnson?
Yes, sir. Mr. Johnson, come on up, please.
Good morning, Mr. Johnson. How are you today?
Good morning, Your Honor.
All right, sir, you're charged with one count of burglary of an unoccupied conveyance. I find probable cause. Mr. Linder?
Your Honor, I'd be requesting a $1,500 bond.
Mr. Romero?
Judge, I'm going to be requesting pretrial release. This is why. Mr. Johnson did advise me there's no one that's going to be able to afford to post his bond. He's 39, been here his whole entire life. More importantly, and I'm sure Mr. Lender will correct me, he says he has a clean record.
Any priors? Hang on, Mr. Romero. Let's
He-
fill in the blanks here so we know what we're all dealing.
He's got a pending case in front of Judge Lerner Wren right now for, and Your Honor, if you just want to take a look, just, that's, I mean,
Okay.
he's had multiple cases dismissed, I imagine on competency grounds, which might offer some explanation for the information he's providing, Mr. Romero. But there is a history. And I took that into consideration when making the recommendation of 1,500, that while, obviously burglaries are serious, I think there is some mitigating information regarding his, situation.
Mr. Romero?
Judge, now I understand the reason as far as why maybe Mr. Johnson gave me that information, why it's not checking out. Having said that, Judge, he does live here locally. He has a residence. He lives in Coral Springs. So I'm asking the court to consider releasing him on pretrial based on the fact that he has a residence here, Judge.
All right, I'm gonna go ahead and release him on pretrial release. Mr. Linder, I understand.
Well, I just wanted to check one thing, Your Honor, because, okay, I understand, Your Honor.
Okay. All right. Mr. Johnson, we're gonna go ahead and put you on pretrial release, okay? Mr. Romero will give you the details on what you need to do. Make sure you follow those recommendations and follow up with what you need to do, okay? Good luck to you, sir.
Make sure you report there, okay? If they're already closed, then you go there first thing tomorrow morning to follow them.
Justin Tabor?
Mr. Taylor, come on up.
You good there? Okay. Good morning, Mr. Tabor. How are you?
Pretty good about yourself.
I'm doing okay today. Thank you very much for asking. Mr. Tabor, you have two counts. You have one fraud, uttering a false instrument, and a grand theft. This looks like these are cases, these are warrants from a 2014 case. You have a $1,000 bond on both counts. So $1,000 on count one, $1,000 on count two. I find probable cause. Mr. Linder, do you wish to be heard?
Yes, Your Honor. I'm going to be requesting a bond increase to $3,500 on each count, Your Honor. I would note, Mr. Tabor was extradited here from, I believe, let me see, from Ohio. He also has a warrant for failure to appear out of the state of Tennessee, and that's from 2012. As you can see, this is a 2014 case where it appears that it took some period of time to locate Mr. Tabor, and I really want to make sure that this case begins to proceed and we don't have, without any additional delay.
Mr. Romero, do you wish to be heard?
Yes, Judge, that is correct. He was extradited from Ohio. That's where Mr. Tabor lives. He lives specifically in Columbus, Ohio. He was working at a place called Anthony's Pizza. Unfortunately, he was, for these many years now, he's been taking care of his fiance. Unfortunately, she did pass away. This year, she was suffering an illness for a long period of time. Judge, he did advise me right now, as far as that Tennessee warrant, he knows nothing about. My understanding is, in speaking with Mr. Tabor, that he has no other priors. This is basically the first time he's been here in front of a judge. Having said that, he's 29 years old. He does realize that now on this case, he's going to have to appear before it. He will not be leaving our state. He'll be here during the duration of this case, Judge. But right now, he was in custody now about a month. So the employment that he had, he basically lost, and he has no sort of savings or anything to post this bond. So, Judge, we're asking for him to be released on pretrial release, taking into account that he's been in custody now for almost 30 days on this case, Judge.
Does he have any priors outside of the
See
Tennessee?
falsification out of Ohio from 2012, but also, Your Honor, I mean, he lives in Ohio. He has no ties to the community. Putting him on pretrial really.
All right, here's what
see
I'm
how
gonna
that would
do.
be
It's gonna be $2,500 bond per count, 1 and 2. Okay, so it's not gonna be the 3,500 that Mr. Linder's asking for, but there will be a slight increase, 2,500 each count, okay? All right, good luck to you, sir. All right, Michael Quintanilla,
Bonded, Judge.
all right. Terrell Harris,
Mr. Harris is here present, Judge.
Mr. Harris, good morning, how are you?
Good morning, I'm doing good. How about yourself, sir?
I'm doing well. All right, Mr. Harris, you're charged with 3 counts. 1 count of burglary, occupied structure unarmed, another count of burglary, unoccupied dwelling unarmed, and 1 count of criminal mischief over $1,000. The criminal mischief count has a $500 bond. I'm going to find probable cause after reading the probable cause affidavit. Mr. Linder, do you want to be heard as to counts 1 through 3 or 1
Yeah, sure.
and
Just
2?
one moment. It'll just be on 1 and 2, but.
Okay.
Oh, and Your Honor, just to note, I spoke to Deputy Jacobson, who authored the PC. Count 1 should be occupied dwelling. It was just a
Okay.
misspoke. His criminal history is 2007 out of Broward, delivery of cocaine. And frankly, what concerns me more, I'm going to be requesting a $15,000 bond on 1 and $10,000 bond on 2. What concerns me more is that he unlawfully entered in the victim's home while he was present. It's obviously always more concerning when someone burglarizes another individual's home. It's even of greater concern when that person is home. It looks like this was done during the day, during the daytime hours. Your Honor, my understanding from information I've received is that he is personally known to the victim. He's done work for him before, so I would also be asking for a no victim contact and no return to this location.
Mr. Romero?
Judge, I haven't had an opportunity to review the PC affidavit, but I probably believe there's more to the story than meets the eye. My understanding, first, as far as Mr. Harris, he does have that delivery offense, but I believe it was over 10 years ago. My understanding, that's his only felony offense. He's a registered voter here in our community. He's been here his whole entire life. He's 35 years old. Now, he works for a local contractor doing home repairs. My understanding is that the alleged victim on this case was one of Mr. Harris' clients. My understanding is basically that client breached his contract. Mr. Harris did work for that individual, and then that person decided not to go ahead and pay Mr. Harris nor pay his employees. Now, Mr. Harris did have his keys, and ultimately, when I believe he filled out an application for the public defender's office, he gives that information to the attorney to relate to the case file. I believe this is probably going to be filed as an occupied trespass and with the criminal mischief, because Mr. Harris basically did have keys to the home. Don't say anything. And as a criminal mischief, Judge, he probably should have he went about it the wrong way. He should have probably take up a civil action against that victim, but unfortunately, the facts speak for themselves. Judge, my point in all this isn't a run-of-the-mill burglary as we usually have here at magistrates. There's more to it. I'm gonna be asking for the court to consider releasing him on pretrial release, because from right now, because he didn't have, that paycheck coming in, he had no money to go ahead and afford to pay his rent this month, pay his workers or anything like that. He just simply doesn't have any money. So I'm asking the court to consider releasing him on pretrial release, and if the court is not comfortable releasing him on stand-up pretrial because of the nature of the charges, I'd ask for a level 2. But that's what we're asking for at this time, Judge.
Your Honor, I would just note, even if we accept everything that Mr. Romero is saying at face value, it still is more than a trespass because there was a crime committed therein, criminal mischief in both apartments. And even if he was given a key, that doesn't mean he can go into the individual's apartment anytime he chooses. And lastly, I haven't heard any allegation that he was doing any work for the neighbor.
All right, we'll do at this point in time, 5,000, 2,500, 500. 5,000 on count 1, 2,500, 2,500 on count 2, and 500 on count 3. All right. Mr. Harris, no contact with the individual. I understand you might have some issues. This might have been work gone wrong. Don't say anything, but I understand you might have had issues regarding work gone wrong. That's not what we're here to determine today, okay? I just need to read what's on the probable cause affidavit and make a determination as to whether there's probable cause and issue a warrant. Issue a bond. The bond will be those, but don't make any contact. If you do have some issues with that individual, if there was work completed, please consult an attorney, okay? So don't make contact, don't call, don't text, don't post about them on social media, don't send messages through anybody else, okay? And no return to the home.
Is there any way that it could be reduced? Because I have like no money and I don't have anything right now. Like I have workers that have been working for me that I can't even pay because this guy said.
Don't talk about the facts.
Yeah, don't say anything about the facts.
I don't have money right now to bond out. That's the thing. Like, I will give you the money later on down the line if I can, because I am an honest, hardworking man. I've been working for, myself. I do everything I can to keep a roof over my head, pay my child support, everything. It's like it's only me out here right now. I've had a past, but I've changed that, and that's the reason why I moved to Pompano area, because I found a better living up here and I've been doing positive things. Unfortunately, I've ran into this situation that, I'm asking if the courts will, grant me, at least pre-trial or something, because I don't have no funds right now.
All right.
Like I have nothing.
I understand. Here's what I'll do. I'll make it 2,500, 2,500, and 500, but I feel comfortable having a monetary bond. You reach out to a friend, try to lower it a little bit for you, help you out, okay? But I think at this point in time, monetary bond is appropriate, okay?
All right, sir.
Good luck to you. All right. David Hinton?
Oh, Judge, Mr. Hinton's here, but unfortunately, if we could put him on recall, I haven't had an opportunity to speak to him.
Okay.
I don't know if you can address the other individuals at the other facilities, Judge.
Okay, I don't know who's got somebody ready.
North Broward's got, Paramore on page 31 ready if you want him.
Okay,
Come on in, Paramore. Good morning, Your Honor.
good morning. Give me 1 second, sir. Brandon Paramore, is that you?
Yes, sir.
All right, good morning, Mr. Paramore. How are you today?
I couldn't be better.
I understand. You are charged with 1 count of grand theft, 1 count of possession of cocaine, 1 count of possession of oxycodone, and 1 count of resisting officer without violence. You currently have a bond of 5,000 on count 1, 1,000 on count 2, 1,000 on count 3, and 100 on count 4. I do find probable cause, having reviewed the documentation. Mr. Linder, anything to add?
Your Honor, I'd ask that the bonds be kept in place. I would note that Mr. Paramore pled out to a grand theft resisting without violence and a petty theft and resisting without violence and was released from county jail 1 week prior to this arrest. He's also got another this year, another case with 2 thefts, a battery in loitering and prowling resisting without violence in 2017, possession of cocaine resisting with violence 2015, possession of stolen credit cards 2015. Just goes on from there, Judge.
Mr. Reedy?
Judge, I'm going to be asking for pretrial release. Mr. Paramore has no monetary funds to afford any kind of monetary bond. He works at Popeyes. He's been a resident of Florida for all of his life. He does have an address that can be used as far as pretrial release to contact him at his sister Ariel's house. But he's not going to be able to afford a monetary bond, Judge. So, again, I'd be asking for pretrial release from Mr. Paramore.
Okay. I think the bonds are reasonable based on everything that I've heard. So at this point in time, we'll leave them as such, 5,000, 1,000, 1,000, and 100. All right? Mr. Paramore, good luck to you.
All right, I'll call your sister for you, Mr. Paramore.
So I wouldn't be able to get pretrial at all?
Not at this time.
Okay, I have to bond out. I only have $285 in my account. Is there a possibility that maybe it can be waived down so I can be able to afford the bond? Because I do work, sir.
I understand. At this point in time, I feel that those bonds are appropriate. All right? Good luck to you.
And how did I plead out the probable cause for the grand theft?
After review of the documentation in regards to, I believe it was I'll bring it back, I believe it was a stolen car, alleged stolen car from Miami-Dade County. Don't say
Don't
anything.
talk about the facts of the case,
Honor?
Mr. Paramore.
Mr. Paramore, Mr. Reedy, your attorney, is giving you excellent advice. Okay, now's not the time to talk about the facts. I'm not finding you guilty. All I'm doing is indicating that according to this piece of paper, that in the 4 corners of the affidavit, there's enough probable cause for them to hold you at this point in time, okay? You'll have an opportunity to go in front of a division judge, have your case heard. If you feel that, that these charges aren't appropriate for you, you'll have your day in court. You have the ability to call witnesses, bring witnesses, cross-examine witnesses, and have a jury if you so choose, okay?
Okay, no problem.
All right, good luck to you.
Thank you.
Are we ready on Mr. Smith?
Let me see something here.
Do you have anybody else ready on any other?
4 round, Your Honor, has 1 left. McKee Daniel.
Daniels? Okay, give me a second. Let me track
The
that.
last one in your docket.
Last one. Okay. Daniel McKee.
Yes.
Good morning, Mr. McKee. How are you today?
Good morning. I'm good, Your Honor.
Okay. You are charged with battery on a person 65 years or older. This is a change of charge from a previous count of robbery by sudden snatching without a firearm or weapon. Mr. Linder?
It's really a lateral change of charge as far as the severity of the offense, Your Honor. Bond was originally set at $5,000, I believe with an order of no victim contact. Just want to confirm that.
So based on the fact that it's a lateral change, are you asking for the bond?
I
remedy?
would be asking that the bond be kept in place, Your Honor. I can tell you, it's against the same alleged victim, it's just a different theory as far.
I understand.
Yeah. But yeah, bond was set at 5,000, no victim contact.
All right. Mr. McKee, basically everything's staying the same. They just changed the charge, being indicated it's a lateral change, so it's same level of charge, just a different type of charge. Mr. Reedy, on Mr. McKee at the end of the docket, it's a change of charge. Apparently, it's a lateral change. The state is requesting that the bond remain the same at $5,000, no victim contact.
Yes, Your Honor, I saw that, and that does appear to be the case.
Okay. All right, Mr. McKee, you're all set. Good luck. All right, and the bond will remain at $5,000.
Thank you.
You're welcome. Are we ready on at Maine, or you need more time? Do you need more time, Mr.?
A couple more, Joe. We can, I believe we left off at
Smith?
David Hinton. I'm ready to proceed.
David Hinton, okay, sure. Okay, good morning, Mr. Hinton. How are you today?
Fair to middling, Your Honor.
I
How are
understand.
you?
I'm doing okay. All right, you have one count, you're charged with one count of burglary, unoccupied structure, unarmed, one count of petty theft, second degree, first offense. And having reviewed the probable cause affidavit, I find that there is probable cause. Mr. Linder?
Your Honor, I'm requesting the $7,500 bond on count one, no return. His criminal history, 2013, convicted felon in possession of firearm or ammunition, and an aggravated assault with a deadly weapon in 2012. He was sentenced on each case to 3 years and 3 months in Florida State Prison, released August 5th, 2017. He's also got, one moment, Judge. As far as offenses he's gone to state prison on, grand theft 2003 out of Broward, he was sentenced to 2.5 years state prison. There are other priors, but those are obviously the most significant.
Okay. Mr. Romero, do you wish to be heard?
Yes, Judge, as you heard, he does have priors, but as you heard also from the state, he was released approximately 2 years ago, and 2 years he's been clean. Now, he's been here his whole entire life, Judge. Right now, he's living in a shelter. What he does for a living is he basically scraps metal. Now, my understanding, I haven't reviewed the PC affidavit, but my understanding it was at a business where he allegedly took metal and things of that nature from a dumpster, Judge. But in speaking of Mr. Hinton, I'm going to be asking the court to consider releasing him on pretrial release. Now, he does have family that live in Broward, specifically his aunt. She's not in a financial position to post his bond. She's actually dealing with her own issues as far as health issues. She was diagnosed with cancer, and Mr. Hinton frequently visits with his aunt, basically trying to motivate her, keeping her spirits up, Judge. He's asking if the court would consider releasing him on pretrial release.
All right. I feel more comfortable with a monetary bond. It'll be $3,500, and we'll leave NC on the petty theft. So it won't be what the state's asking for, but we're gonna set it at $3,500 as to count one, okay? All right, good luck to you, Mr. Hinton. Anthony Smith?
Mr. Smith, come on up, please.
All right, good morning, Mr. Smith. How are you today?
Good morning, sir.
All right, so you're charged with two counts. One count of distributing, delivery cocaine, the second count of distributing, delivering cocaine. There is a bond for each count of $2,500. I find probable cause based on the probable cause affidavit. Mr. Linder, do you wish to be heard?
No, Your Honor.
Mr. Romero?
Not at this time. I'm going to be contacting his mother to post his bond, Judge.
All right, good luck to you, Mr. Smith.
Mr. Doe?
Vandero Doe?
He's approaching, Judge, here at Maine.
Good morning, Mr. Doe. How are you today?
Good morning, sir. I'm good.
All right, you are charged with one count of grand theft auto. It has a $1,000 bond. Having reviewed the probable cause affidavit, I find there is probable cause. Anything to add, Mr. Linder?
Nothing from the state.
Mr. Romero?
Judge, we're going to be requesting the court consider releasing him ROR pretrial release. My understanding, he has, I believe, maybe one contact. He advised me of a 2015 misdemeanor offense. He's been here his whole life, 19 years old, so we're seeing if the state has any objection having Mr. Doe released on pretrial release.
Any objection to pretrial?
No objection to pretrial.
Pretrial it is. All right, Mr. Doe, good luck to you.
Sir, thank you.
Make sure you follow the directions that Mr. Romero is going to give you there, okay?
See the map right there? They're closed because they're probably going to be closed by the time you get out. Report tomorrow morning. Good luck.
All right, we're on Mr. Butler.
Mr. Butler, come on up, please.
His bond's posted? Bond posted.
Perfect, that's it. Yep. Bond was posted.
You're all set, Mr. Butler. Good luck to you. Brandon, I'm sorry? Yes. Signed and checked off. Brandon Avails,
Medical reset.
medical reset.
And Judge, I'm going to need another little break, Judge.
Sure. Do we have anything else in any of the other facilities?
Oh, wait, Judge, there's one person, John Young. John Young? He declined the service as a public defender, so he could go forward.
All right, let's take care of Mr. Young. Good morning, Mr. Young. How are you today?
I can be better. Good morning.
I understand. All right, so you're charged with one count of possession of blank or unlawfully issued driver's license. Having reviewed the probable cause affidavit, I find that there is PC. There is a $1,000 bond currently on the charge. Mr. Linder, is there anything to add?
Not at this time, Your Honor.
All right, so you have a $1,000 bond. You can contact somebody and post that bond. You can get out, okay?
All right, thank you.
Good luck to you, sir. Do we have anyone available at any of the other facilities?
I don't think so.
You got any?
You should double check with North Broward.
Let's see. North Broward, anything? Okay. Do you want me to take a quick recess so we can get caught up, or?
That's fine.
All right.
Your Honor, actually,
Anthony Jasmine?
Which case?
Jordan Cheese.
you don't have to call now.
Okay.
It's a down file, so.
Couldn't hear you. Okay. Sure. Let me take a look at it real quick.
It's an incident report, not a PC. I'm sorry, Homea Spence.
All right. We'll be in a very brief recess while we get caught up. Back. Sorry for the brief recess. All caught up?
Thank you very much, Judge, for giving me that opportunity to catch up.
Absolutely. That, you have enough time? You need more? You're good? Fantastic.
Perfect.
All right, and let's go back with Noah Littlepage.
Mr. Littlepage, come on up, please.
Thank you. Y'all are good over there? Okay, good. You all are good on this side? All right, fantastic. All right, Mr. Littlepage, good morning. You are charged with one count of driving while license suspended. Looks like habitual offender. And having reviewed the probable cause affidavit, I find that there is probable cause. There is a current bond of $750. Anything to add, folks?
Yes, Judge. I'm going to be asking if the court would consider releasing Mr. Littlepage on standard pretrial release. My understanding he is working. He works at a company called ABA Miami, where it's like an audio-visual company where he's been employed for about 1 year. Normally, he wouldn't have a problem paying the bond, but unfortunately, it's the beginning of the month. He just basically paid the rent. Him and his girlfriend and his son, I believe, just recently went on a little mini vacation, and right now he has no income, no sort of savings to help post this monetary bond. He's basically, his girlfriend doesn't work, so he's the breadwinner of the family. They live here in Hollywood locally, where they rent, they do not own. So we're asking if the court would consider releasing him under standard pretrial on this non-violent offense.
Any
Judge.
issues with pretrial release?
No, Your Honor, I don't believe he's a good candidate for pretrial. He just last month just pled out 2 DWSs. I'm showing on his driving record, he's been suspended, let's see, 1, 2, 3, 4, 5, 6, 7 times for failures to appear in court. And he's got 1.
I actually had other court dates in Miami, and then I actually came to the court. So it wasn't really to appear. I can be in 2 places at one time.
Judge, in speaking to Mr. Littlepage, he's saying that he's not negating that he missed court, but there is a reason why he missed court. And also, my understanding is, as the state just said, he recently resolved, I believe, a driving offense, but he's advised me that the date of incident on that driving offense wasn't recent. So we're still maintaining our position as far as requesting for pretrial release.
And you're right. On one of them, at least one of them, he failed to appear in that case. And, I understand if it was 1 or 2 failures to appear, but when you start getting to 8 or 9, you really can't explain every single one away.
And in addition, 2003, he was arrested in Colorado for escaping, and the underlying charge of the violation of public safety.
All right. I don't have an issue with the charge. I think my concern is just the failures to appear. All right, so based on that, I'm just going to leave the bond as is.
Your Honor, when I did have the failure to appears, I actually had court dates in Miami. It does show it. You can see that I did have a bad history, but once I got this new job, I have been getting my life straightened. I do have a criminal history. Now it's the driving that got caught up with me, but this job has changed my life, and my girlfriend and her son has changed my life. If I stay in jail, I'm gonna end up losing my job, and don't know how I'm gonna pay the rent. I mean, I know I had a bad past, but this job has changed my life, and please don't let this ruin it for me. Please let me move forward. I promise I'm gonna show up to court. You can see that I've been going to the court dates. I've been trying to get my life together, and I have been getting my life together.
All right, hang tight for a second.
Your Honor, and I would note, his failure to appear suspensions are at both Dade and Broward. I just noticed, I'd refer the court's attention to his booking sheet and just the number of aliases he's used in the past.
Again, Mr. Littlepage, I would totally put you on pretrial release on this charge. I don't have an issue with that. I think it's just the 8 to 9 failures to appear. I understand that you indicated you had court on those, but 8 to 9 is, that's a lot when we start to get into that number, okay? I don't think 750 is unreasonable. I think that is a fairly reasonable bond, so we're gonna go ahead and leave the bond at 750, okay?
Your Honor, how long ago were those failure to appears? You'll see that it's been in my past. I'm trying to move forward with my life. If I can't bond down and I lose my job, this is really going to put a big hold up on my life. It really will. I'm taking care of my girlfriend and her son. I'm not, please, pretrial, just let me get out so I can work and come to court. You can see the failure to appears were a while ago. Now, there was a failure
One was
to
June
appear that
13th, the other was May
recently.
9th.
Those were two.
Those are two.
Because I had court in Miami on that same day. And you can ask Mr. Chung, that was my public offender, that he was aware of it, and I actually got him to set a new court date because I missed that court date. You know, because I couldn't be in two places at one time. You can ask Mr. Chung. This is all verifiable. I'm not trying to play around with the system here. I mean, I'm just asking mercy for the courts. I really am. I'm being respectfully pleased, you know, and honestly. I promise you I'll show up to court. I'm not trying to run from this, nothing. I'm trying to get on with my life. You know, and this job that I have is actually a good job, and it's a great opportunity for me. I had it for like a year now. I never had an opportunity like this before in my life, and, you know, I'm trying to run with it. You know, it's audio, video, automation. I mean, it's a very good trade. I'm happy with it. I take pride in it. I love my job, and I don't want to lose it. I really don't.
Did you have anything to add, Mr. Linder?
One moment, Your Honor. Yeah, Your Honor, he can, Your Honor, Mr. Littlepage can say whatever he wants, but the actions speak louder than words. The KPSC was arrested on February of this year for failure to appear in a 2018 case. One moment, let me see. Let's see. He failed to appear at a hearing before Judge Davis February 19th. He was arrested and ROR'd on the KPS. Then he failed to appear at his jury trial on May 14th of this year, set before Judge Malika.
That was Miami, when I had court in there.
And then
Mr. Davis, that was, from my understanding, Mr. Davis, that was in South Courthouse. That was supposed to get transferred to the Central Courthouse. That was a misunderstanding there. You know, I'm really not trying to play no games here. I mean, I'm really trying to get on with my life. I'm not, you know, I've been going to the court dates. You know, that was a misunderstanding on that part. You know, but like I said, on the court date, May 9th, I believe it was, I had a court in Miami-Dade at that same time.
No, and Your Honor, I don't believe that either, because I'm looking at the court notice. He was given in court by Judge Davis on January 19th, which said, be in court February 19th, fix your driver's license. There was nothing to indicate he was supposed to go to Central.
Respectfully,
And
folks.
she kept giving me continuances, you know, thank her for that. And I was trying to get my license together. I had a hold that was out there in, a hold up in Colorado, and that's the reason why I didn't. If you can see, I got caught up on it. It cost so much money to get caught up on all my payments. Unfortunately, now my payments fell behind, so I started a couple payment plans to get my license. But, you know, I have been trying to take care of everything, you know, and like I said, I'm taking care of my girlfriend and her son. And right now, I don't get paid until Friday, and if I don't work the rest of this week, I'm afraid, you know, my job's gonna be in jeopardy. And I really love this job.
I understand, and respectfully, I'm going to leave the bond at $750. Thank you very much. Good luck. All right, Anthony Jasmine.
Bonded.
Jordan Cheeseborough.
He's approaching Judge here at Maine.
All right, good morning, Mr. Cheeseborough. How are you today?
Good, and you?
I'm doing well. All right, sir, you are charged with one count of a burglary occupied dwelling, a second count of burglary unoccupied conveyance, a count of grand theft, illegal use of a credit card for count 4, and count 5 is a grand theft. The counts 3, 4, and 5 each have a bond of $1,000. Mr. Linder?
Your Honor, on count 1, breaking into the occupied home, I'm requesting a bond of $20,000. On count 2, $5,000. Pretrial release of the GPS monitor. Your Honor, my concern is, as you can see, he's 18. He's currently on juvenile probation for 2 burglaries of conveyances and a grand theft auto, with 2 pending burglary conveyances from March of this year.
Mr. Romero?
Judge, I do understand he has a record, and these are burglary offenses, but he is 18 years old. He is going to school. From what he informed me, Judge, he's about 2 credits short of getting his high school diploma. He attends Perry High School. He eventually wants to get those two credits so he can receive his high school diploma because he wants to go on and attend Broward College where he wants to be a dentist. That's his ultimate dream. Having said that, Judge, he doesn't have the financial resource to post bond, so he's entirely going to be depending on his parents to help post his bond. My understanding is they do know he's here. He did advise me that they will pay his bond. He doesn't know their financial resources. He knows they live here locally in Miramar. His father and his mother, I believe, have their own insurance company, but he doesn't know their finances. So I'm going to be requesting on count one, Judge, a $7,500 bond, and on count two, $5,000 bond is reasonable, Judge.
All right, it's gonna be 10,000 on count one, 5,000 on count two, count three, four, and five will be $1,000 apiece. Pretrial release GPS monitor on, Mr. Cheeseborough, okay? Good luck to you, Mr. Cheeseborough. If I didn't indicate earlier, found probable cause.
And Your Honor, I apologize. I would just also ask no return, no victim contact.
Yes, no return to the locations, no contact with any of the victims. Do you understand that, Mr. Cheeseborough?
Would you need it?
Yes.
All right, good luck to you. Justin Sarmiento,
Judge, he bonded?
bonded. Juan Nguyen,
He's approaching, Judge. My understanding has private counsel, and I believe his private counsel. I don't know, Mr. Reedy has information.
Yeah, his private attorney was here. It's a. Are you still here? Yeah, Mr. Murphy represents Mr. Gwynn on other cases, but has not been retained as of yet to represent him on these charges. So at this point, I would recommend to Mr. Gwynn that he avail himself of the services of the Public Defender's Office so that he can have representation here this morning. It's either that or he can represent himself because Mr. Murphy has not been retained.
okay.
Judge, I'm going to need a moment to speak to Mr. Gwynn. I was unaware of this.
Okay, go ahead, take a moment. So you're on his other, you have other cases, but you're not here on this one. Are you here for something else? Understood, okay. I just didn't want you sitting around waiting if you've got places to be. Absolutely. Meantime, Mr. Reedy, are there any other cases that we can call? I was saying, are there any other cases we can call in the meantime?
I don't think so.
Okay, no worries. Markinson. Jenny Markinson, got it. All right. Scott York. So Toro Botero and Yorick Scott. You good? All right, perfect.
Yeah, I think if North Broward isn't saying anything, then coma shock would be probably a reset because he's at North Broward. He was a medical reset yesterday.
All right, well, I got that next, so let's,
We're ready to proceed, Judge.
ready? Okay,
For giving me that opportunity once again, Judge.
absolutely, anytime. All right, so we're on Mr. Gwynn. Good morning, Mr. Gwynn, how are you today?
Good, how you doing, sir?
I'm doing well, thank you for asking. Mr. Gwynn, you are charged with 2 counts. Count 1 is aggravated battery, cause bodily harm. That is count 1. Count 2 is false imprisonment. And having reviewed the probable cause affidavit, I do find probable cause. Let me hear from Mr. Linder.
Your Honor, the state is going to be requesting a $50,000 bond on 1, a $25,000 bond on count 2, no victim contact, pretrial release of the GPS monitor level 1. Your Honor, the state has a great concern for the safety not only of this victim, but the community, particularly women in this Pompano Beach area. Your Honor, as you can see, the report makes reference to other recent investigations. Mr. Gwynn is currently out right now on a pending exposure of sexual organs, where it's alleged that he exposed himself to another woman. The incident location in that case is approximately a mile from the incident location in this case. Now, obviously, it's up to the court whether you choose to sua sponte revoke on that case or not. That is your call. He also has a pending possession, looks like a couple pending possessions of cannabis, resisting without violence 2016, theft 2014. I would also just note the injuries suffered by the victim in this case and the specific details on the level of violence that is alleged to have been committed against her, Your Honor.
Mr. Romero?
Judge, I understand the nature of the allegations are quite serious. But having said that, Judge, $75,000 for Mr. Gwynn, that's tantamount to no bond. He's not in a financial position to come anywhere close to that. Now, he works for a company called Cool USA, where he's been employed there for about 3 years as an AC technician. He makes approximately $17 an hour. He's been here his whole life. He's 27 years old. He lives in Deerfield, where he rents by himself, and his rent is approximately $700 per month. He has basically no money in the bank, but he does own property. He owns a Chevy Monte Carlo, I believe it's 1996, and he advised me is probably over 170,000 miles on it. So he doesn't know the resale value, but he's probably sure it's pretty low. Having said that, Judge, he does have family that live in our community that he's going to be depending on their help to help post his monetary bond, specifically his grandfather. From what he advised me, his grandfather's on a fixed income. He receives disability, so his financials are quite limited. I'm going to be asking for a $5,000 bond on count 1, $25 bond on count 2. That would be a $7,500, which the defense is requesting. Judge, I do understand that is a low monetary bond that we're requesting, but that is his financial resources. Because the nature of the charges, we wouldn't have an objection if the court also, besides the monetary bond, wanted to have him supervised. Now, the case that he is currently on, I believe it's a misdemeanor offense. I believe he has a local counsel, and I believe, from my understanding, local counsel is present. So if the court wanted to take any action on that, I believe his probably private counsel would have some sort of information regarding that case. But if this case was here before you, Judge, I'm asking for a total of $7,500 bond on Mr. Gwynn's behalf.
Your Honor, the only thing I would note, just for record purposes, the courts have been very clear that a bond will only be determined to be tantamount to no bond when it is considered so excessive in consideration of all the statutory factors for the court to consider, not merely because it is an amount more than the defense claims the defendant can afford.
I understand. Mr. Murphy, what's the status as to, it's Mr. Murphy, right? Did I get that right? What's the status as to the pending charges? Do you have court soon? What? I understand. I did find the allegations, and Mr. Gwynn, it's important that you realize that's exactly what they are, allegations, okay? I'm not here to find guilt or innocence. I'm not here to determine whether you are or not guilty. I just read the four corners of this document that's provided to me. You have an opportunity to go to court, and you obviously have an attorney representing you on a number of cases, and you have the services of the public defender right now on this case. So you'll have your day in court to argue whether this is or isn't appropriate. However, I did find the allegations to be concerning, and more importantly, the fact that there's another pending allegation regarding exposure of sexual organs. I am going to, it's going to be a $50,000 bond on count one, $25,000 bond on count two, no victim contact, GPS level one. I am going to sua sponte revoke the bond on the pending charge for exposure of sexual organs. Mr. Murphy, so you're aware that'll happen, so if you want to move up the court date or address that in court, no issues here. Division may find that, that's not appropriate, but for the purposes of what's going on right now, I'm going to go ahead and sua sponte revoke the bond on that case and hold it, no bond. Anything else at this point in time?
Nothing from the state, Judge.
All right, Mr. Romero, anything else?
Not at this time, Judge.
All right, Mr. Gwynn, good luck to you.
No, here. She's out.
All right, we have Matthew Komashak.
Judge, Mr. Komashak is going to be a medical reset, and I would ask that he be set not for tomorrow, but for Friday.
Okay, reset Mr. Komashak for Friday. Colindris Manguai? I don't know if I said that right.
Judge, he's in regular court, room number 6870.
I got you.
Okay. That's an immigration hold. Apparently, he's got court today.
Normally I would, I'm sorry. Normally I would, I just got a million.
Yes.
We're gonna have to
Yeah.
magistrate him on that.
Well, I mean, it is an immigration hold. You all want to reset it for this afternoon, or?
Tomorrow would, I think, be preferable, Judge. If he's in regular court, we don't know when we'll get him back here.
Okay, tomorrow it is. Thank you, Mr.
He's
Reedy.
not going anywhere anyways.
And then Willie Johnson.
He's approaching, Judge, here at me.
All right. Good morning, Mr. Johnson. How are you today?
I'm doing all right, sir.
Okay, you are charged with 2 counts. The first count is attempted murder, second degree. The second count is a possession of a firearm by a felon. And this looks to be a change of charge. Apparently, the previous charge was,
It's another technicality, Your Honor.
I see that. I was just making heads or tails of it right now. All right.
Judge Powell,
Mhm.
at his original first appearance, set bonds in the amount of $75,000 on count one, $5,000 on count two, no victim contact, no firearms or weapons, and pretrial release with a GPS monitor.
All right.
That is correct, Judge. He's been in custody, I believe, now for about 32 days. There's no one that can afford to pay his $80,000 bond. He's 70 years old. He gets Social Security. His brother, his family, he's on Social Security as well, so there's no way they can afford that monetary bond. He's asking if the court will consider a bond reduction.
I don't feel comfortable changing the previous findings on the bond. I do appreciate the request, Mr. Romero, but I just don't feel that I have enough information. They only give me here the change of charge. There was already a judge that reviewed the probable cause affidavit and made a determination based on that, and I don't feel comfortable disturbing that. So I'll leave everything the same. It'll be $75,000 as to count one, $5,000 as to count two. No victim contact, pretrial release, GPS monitor, everything as it was indicated previously. Mr. Johnson, good luck to you, okay? Whatever it was before. All right. We have Homea Spence.
Judge, I've been advised he's in regular court.
Okay, so reset for tomorrow. And Shaheem Jean-Philippe.
Cantillon, he's in court, room 770.
Your Honor?
Yes.
I'm gonna ask the court, in this matter, he's being arraigned on these charges. If I may approach?
Yes.
He was on pretrial in this case, and he was arrested on a new charge. His pretrial was revoked, and he was ordered to be held no bond. I would ask the court to keep the no bond hold in place pursuant to the signed order. It's not as though he needs to be brought back to be advised of these charges. He's in front of his judge for that very purpose this morning.
So he's in front of his judge on this case?
Yes, for arraignment, yes.
Okay, well then, what do y'all need? It sounds like this is,
I'm just asking the court, since, having provided the previous order.
I'm gonna leave it alone. I'm not gonna mess with the order.
So I'm just asking if you just, the jail needs it to be ordered by your honor, so he doesn't keep getting brought back here.
Understood, so that'll be the case. All right, anything else in regards to?
Mr. Harris will be here. Oh, I'm sorry, go ahead.
Correct. Count 2 and 3 is no bond.
I checked with BSO, and Mr. Alton Harris will be here this afternoon at 1 o'clock.
Okay, fantastic, and I trust y'all will take care of everything. Please bring Chief
Yes.
Judge Tudor up to speed as to why Mr. Harris is here.
We will.
I'm sorry? Yes, absolutely. Sorry about that, I had that set aside. All right, anything else? Mr. Linder, is there
Just-
anything that?
I'm just finishing an order for the court.
Okay, all right,
I
great.
have an order as well.
All right, anything else, folks, besides the orders that need to be signed?
No, sir.
All right, thank you all very much. Thank you.
Always a pleasure, Judge.
A pleasure. Thank you all for your help today. I don't get to do this often.
Well, you know where to find us.